Fourth Department, hear ye. All persons having business before this court will draw near, give attendance, and they shall be heard. Just with your.
Old habits die hard.
Sorry, I'm used to being in the middle.
Thank you, please be seated. The first case out for argument today is case 892, People versus Scott.
Could we get a call on 898 as well?
Oh, and 898, yep, thank you, of course, my apologies for that. Proceed, counsel.
Good morning. William Easton from Rochester for Mr. Scott. This case, I think, presents an extraordinary set of facts. It involves the issue of criminal liability for intentional murder and a non-participating co-defendant. And it brings to an intersection.
Does it matter? What if the evidence were to show clearly that that your client, right, the driver of the vehicle, knew that the co-defendant had a gun? Does that make a difference?
Yeah, I struggled with that question a lot. There's no case I found on this. I don't think it would. I think it makes it a much closer case. But using the analysis from Crowley, that even if as a non-participating co-defendant, I know that my co-defendant is up to no good, and that he's taking elaborate measures to conceal things, and there's criminal activity afoot, maybe, that's not enough for intentional murder. It has to be the murder. And so the gun would take it closer to murder, but you could have a gun and not intend to use it or to kill someone.
In other words, you could have a gun and intend to rob someone.
Yes, exactly. And that's the point the Crowley court makes, is that in Crowley, it was pretty obvious that the co-defendant was up to something. And there were elaborate efforts afterwards with prior inconsistent statements. But what the Crowley court seized on, and has been cited with approval from this court, is that that's not enough. It's that defendant could have used that gun for a robbery, or extortion, for a host of criminal actions that did not involve the intentional killing. And that is completely consistent with this court's line of cases. McDonald, which was after Crowley, which cites with approval that doctrine, and Ramos as well. So there's a clear demarcation of cases involving the linchpin. The ironclad rule is that the non-participating co-defendant must harbor the exact intent for murder specifically. And then when you apply that, the gun makes it much closer, but still, I think doesn't do it. It kind of brings to head that case, it's Fournay that we cite in our brief. It's a ghastly case from New York City where the co-defendant is on like a video, and the defendant or the co-defendant is burning a guy. He takes a homeless person outside of a deli, pours lighter fluid on him and ignites him. And the co-defendant, which was at issue, was a guy that was videotaping that ghastly scenario and basically saying, "Do it, man, do it." And it was a divided court, but the Second Department said, no, it's not enough. You don't know he harbored that intent. So it's a very strict doctrine that this court and the Court of Appeals has put forth on the liability for intentional murder on an absent co-defendant. It's very strict. And when I at least think about it, it has to be. Because if you allow that to be breached, you're essentially allowing mere presence to be enough. And that's one of the guiding principles of liability in the case. So that the gun makes it closer, but I don't think it brings it there. And also what was that issue is post-killing, post-crime activity, which this court focused in on McDonald and Ramos, is not an issue. That's not going to be enough to take it up and rescue an otherwise insufficient case. Is in McDonald, this court goes so far as to say, look, you could dispose of property, you could do all sorts of things post-crime, but it's not going to elevate the quantum of proof necessary for an absent co-defendant in a pure circumstantial case. I mean, what makes this case, I think, not easier, but I think it's more definable, is the proper concessions made by the prosecution here, that this was an entirely and pure circumstantial case, which oddly enough, they didn't consent to the circumstantial evidence jury instruction, even though the court gave it anyway. But that is the linchpin here is the intent, and if the intent isn't there.
I think we have that argument. Counsel, do you want to be heard on 898, the tampering issue, or do you want to submit?
I would, I think I'll submit on that, Your Honor. It seems to be that there isn't really an issue on the Fugazana nature of the plea. It was definitely a Fugazana plea, and it was influenced, if not instigated, by the other charge. But what's at issue here is waiver. The issue is, was it waived? And I think, we've set that forth in our papers. There's not much to add to that. We think that in under these circumstances, it was not waived, especially Mr. Thompson at the end said, we don't think it is waivable. And they proceeded to sentence anyway, in light of the knowledge that at least the defense position was not waivable. The one thing I would like to just touch on is the prosecutorial misconduct point.
Just be mindful of your time.
What's that?
Just be mindful of your time.
And in that particular case, the misconduct here, I think, was severe. And I think it went to injecting gang references in this case, where there was no evidence of any gang involvement in anything with any of the participants. The only argument put forth was that it was an urban neighborhood that had presence of gangs in it, which the trial court said, can you link it in any way to any of the participants here? And the prosecutor could not. And so the persistent efforts to inject that were absolutely improper, but also absolutely prejudicial. Is that motive was absent.
Mr. Easton, how much of that was preserved?
I think it was preserved in the sense that Mr. Thompson put forth.
How much of your argument was preserved? I thought it was basically the questioning of two witnesses and the motion for mistrial that wasn't renewed again. But you, in your brief, as the people point out in their brief, you do seem to go down to a prosecutorial misconduct chain that goes beyond the gang activity. And to my read, all that is unpreserved. Is that a fair read?
I think a vast portion is unpreserved. Not all of it isn't. I mean, Mr. Thompson said this has happened 5 times, and I should have objected earlier. I just thought it would end. It's not ending. It's continuing, and I think that's preserved, and it preserves a lot of issues with it. But in terms of globally, though, what happened here is the prosecutor. The phrase that I think rankled me, at least, was the phrase that Mr. Scott was breathing the same air in his car as the co-defendant. And I think that's misconduct.
That was in the opening statement.
The opening statement, yes.
Was that
twice.
preserved?
That was preserved, no, it was not preserved during the opening statement. But I think it's grievous enough, and it gains its prejudicial value during the course of a trial. So at the end of a trial, that is an improper remark, basically eroding the notion that mere presence is never.
But counsel, the whole idea of the preservation is to give the court an opportunity once the objection's made to do a cure. In other words, to tell the jury to disregard those remarks if it's an appropriate thing to do. And without that, then the argument is always they're preserving an appealable issue by not objecting at openings, and that's a troubling situation to get into in these cases.
Yes, Your Honor, and I do believe there are issues. Preserving an opening can be a more difficult task than preserving it in summation, because you don't know yet an opening where the case would go and how egregious or how improper the remarks are. But I think at the summation phase, I mean, the objection was not pro forma, and was laid out how the prosecutor has continually injected without basis the notion of this could be gang related with no basis, and then it gives the jury that extra, well, in this case, the essential component, because as the Carter case from this court ruled, is that in a circumstantial evidence case, motive is not just, it assumes an enhanced position. It's not just a factor, it's the controlling factor. And motive, if you have no other evidence, in this case, there was no other evidence, the lack of motive is fatal and was present here. And there was no, that's why I think the prosecutor made these persistent efforts to try to inject a gang.
We'll take a hard look at that, counsel. Thank you.
Thank you.
Morning, Marty McCarthy for the people. I'll just start at the Fugazzotto thing. I don't think waiver covers that. But for the reasons I put forth in my brief, the court made it clear on the plea that the plea to the tampering charge was not contingent in any way on anything that happened on the murder charge. So if no other questions on that, I'll move to the evidence issues that.
Please do.
So as Mr. Easton pointed out, I did concede that this is a circumstantial evidence case. And I guess the way to sort of compare this case is to compare it against Ramos, which is, I think, one of the more recent vintage cases that this court has had on this issue. There were some differences between this case and Ramos. Ramos was a scenario where the defendant had parked his car over a block away from the murder scene. And part of the court's decision in Ramos was there was no way that the defendant in Ramos could have known that the murder was taking place. Here, you have a very different set of facts than Ramos. This wasn't just a scenario where Ramos drives to the vicinity, drops him off, and sort of waits a block away. This defendant drove him to the vicinity, got out of his car, talked to somebody that he claimed to kind of barely know, even though they talked over 780 times over the course of a month. After that, drops him off, changes positions of the car. It's clear that there's when you watch the video, it's clear that there's a shooting going on. And as the point pointed out, there is evidence in the record to support the contention that the defendant knew that the co-defendant had a gun. So in that scenario, you have that as well. In terms of the defendant's statements about what he was doing and why he was doing it, To say that he was sort of an Uber driver offering rides to people for $10, it doesn't make any sense. He picked this defendant up.
Wasn't it actually what he was doing? I mean, he picked up Mr. Harris on the way as well and dropped him off at his girlfriend's house. I mean, if
Who else?
he knew that they were going to, commit this act, if there was an intent on Mr. Scott's part to transport this co-defendant there to commit this act that he did, why would he pick up somebody else?
One, because he was dropping him off in the vicinity. Two, they were friendly to each other. In fact,
Isn't that evidence then that he is this Uber-like driver then? I mean, he's just
really conflicts with what he was doing with the co-defendant.
dropping him off.
It's not necessarily, it doesn't necessarily conflict, if you will. No, I didn't quite answer that correctly. It doesn't necessarily mean that he wasn't also, that he was an Uber driver for his friend, the guy he drops off at his girlfriend's house. But the co-defendant to the other defendant shooting the victim in this scenario.
And what about the fact that afterwards, we talked a little bit about post. I mean, in this circumstance, he picked him up again, or he entered the car. The defendant entered the co-defendant entered the car. Then he went to what did he end up doing? He went to get gas, right? I mean, if you're part of this act to commit this murder, and you're aware of the fact, you're driving back and you're going to pick up some gas, and then you're going to get a stop. Or wouldn't you just proceed to try and get away as soon as possible?
Well, in the sense of getting away, they didn't necessarily have to. They didn't go far. So that the facts are what they are. The act of getting gas put him on camera.
And I think this is all the fact of circumstantial evidence.
It's
right?
all, yeah, for good or for ill.
Mr. McCarthy, I kind of come back to where the presiding justice sort of started in the questioning. That is, and as I understand it, isn't all the proof that you rely on equally applicable to whether Holt was going to do a robbery, an assault? There's nothing peculiar here that ties it to an intent to murder. And that seems to be sort of the prevalent concept, at least that is really impacting me in terms of looking at the facts of this case, because you don't have any prior communication between Holt and defendant. No text, even though you apparently had access to cell phones. No previous knowledge of one another. And there's nothing that kind of carries this over where it could be a shared intent to murder. So back to my question, isn't all the proof that you rely on equal capable of applying to an assault or a robbery?
So I suppose when you put it that way, because there are two questions raised on this appeal, sort of legal sufficiency and weight. You had the one thing that you never, unless a defendant confesses, you have to rely on circumstantial proof of intent. And in this scenario, the fact that you say that they didn't have any contact beforehand, to me, is also an inconsistency, because how did he know to pick them up? Right? So,
but isn't there a gap in your proof? You say in your brief twice at page 12, there's no explanation of that fact and no explanation of another fact. Isn't the absence of an explanation, and isn't arguing in your brief the absence of an explanation, a gap in your proof?
In a sense, it has to be, because the evidence is what it was. In this case, there wasn't a confession. In this case, there were no cell phone records between the co-defendant and the defendant. In this case, they didn't call each other, but somehow he knew to pick this guy up, to be an Uber driver for this guy. We know that.
Isn't it like word of mouth? I mean, that's basically how he got his rides, wasn't it? I mean,
Well, his other friend called him. Oh, I'm sorry.
right. You get a number, you call.
Yeah.
And maybe it's the first time he picked him up.
But there was no record of them talking to each other in that scenario. So there's no evidence that the two of them communicated.
Remind me of the record in this case, counsel. Is there affirmative evidence that there's no record? In other words, was somebody did somebody testify that I went through all the records of this phone and I went through all the records of that phone, and there was no evidence of contact between, or is there just, there's nothing in the record?
The
Do you see the difference?
yes, and the way I remember it, and if I misremember it, I apologize. It's been a while since I've done this brief. There was the defendant's cell phone records, which were in, which is why we knew that there was over 700 calls between him and the individual who was working on the house on Baldwin Street.
And those records weren't redacted, remind me, were they redacted? Were they only isolated with respect to the friend that he had the conversations with?
No,
I just don't recall.
I believe they weren't. And then I believe they also got the cell phone records for the co-defendant, and there was no matchup between the two of them.
Okay, thank you.
There were no other questions?
Thank you.
Thank you.
Case 894 and 895, People versus Brinson.
Morning, Your Honors.
Proceed, counsel.
May it please the court, Guy Talia on behalf of defendant appellant Blaine Brinson. I'd like to focus this morning on my argument points 1 and 2, beginning with the Supreme Court's error in denying Mr. Brinson's motion to dismiss the indictment based upon the People's Speedy Trial violation resulting from their improper certificate of compliance and the illusory statement of readiness. Let's start with the undisputed issues in this case. It's undisputed that so-called automatic discovery that had been in existence and people's possession since the inception or very near the inception of this case not been disclosed until a year later on the eve of trial, approximately 9 months after the people's initial certificate of compliance was issued. It's undisputed that the standard for evaluating whether that initial COC was nonetheless proper is whether the people exercised due diligence and made reasonable inquiries to discover those admitted materials. And it's also undisputed that the people response to the motion raised no issues concerning their due diligence or any reasonable inquiries that they made for issuing the initial COC.
In terms of the start of trial, when was the 3030 motion filed?
There was a short time period, Your Honor, and it was the day before the trial, and the 3030 motion was filed.
And it was a few days before the trial that certain information was made available to defense counsel. That's my understanding, right?
That's absolutely correct, Your Honor.
And the motion was made on papers.
Yes. Yes.
Just before trial. Here's where I want to be more have a clear understanding. Once the paper motion was filed, the court then heard that motion, correct?
Yes, that's correct. Your Honor.
Right. The prosecution didn't put any papers in opposition to the motion. Is that right?
That's correct. Nor did they ask for any the opportunity to present any opposition in writing. They decided to deal with it at the oral argument and the hearing.
And the court issued a oral decision from the bench.
Yes, it did. I believe it did, Your Honor. And so, yeah, to your point, the motion was filed the day before, but it only was because they had just gotten the belated disclosures. And the people went to the hearing on the motion, which the court held the next day before the trial. And they did not ask for more time. They did not ask for any opportunity to submit a written opposition. The DADA said, Your Honor, I'd like to respond to the motion. He said, go ahead. He offered his own responses, which was that he only became aware of the documents with respect to one of the belated disclosures. He only became aware of it and he turned it over as soon as possible. The defense counsel even pointed out, that's not a sound argument, under this standard. And he still chose to do nothing. So, faced with those circumstances, the people do what the only thing they can do and argue for the first time on appeal that the reason why it wasn't discussed is because they didn't have an opportunity to do so. And that's plainly not Correct. I mean, the record reveals that they had the opportunity. They chose to rely on the oral argument, and that's what they're stuck with. And even People's Brief acknowledges that, the oral argument was sufficient response, and the court essentially had a hearing to resolve the issues of fact. So under those circumstances, the law is very clear, that they don't get a remittal to determine things that could have been raised below, but were not.
I just need to have the record explained to me a little bit better for my purposes. The missing material, counsel, is first what is referred to in the record as a firearms report. Is that correct?
Yeah, so that was one of the,
And if I understand it correctly, and if I don't have it right, please let me know, because I want to go back and look at it in the record. But the argument is that information, because it did not show a fingerprint match to the weapon, that was exculpatory, that should have been produced as part of Brady. That was the argument?
that was one of the arguments that defense counsel made for sure. She did argue that they should have been turned over as Brady material, but the motion also identifies it as one of the items of discovery that should have been disclosed under Article CPL 245.
Okay.
So that was one of. She did argue that it should have been.
It's in the 3030 disclosure that whatever it is, I've got a copy here somewhere. But is that firearms report per se, is that in itself in the record?
I don't believe the actual report is in the record, Your Honor. It was quite a lengthy report, and I didn't see it in the appendix there.
And then the other aspect of missing materials, according to the motion, as I understand, by the way, the motion was filed the day before trial started, correct?
Yes, because that's just
Okay.
when they received the disclosures, yes.
But the other information that's missing is Giglio material that has
Correct.
to do with information pertaining to the testifying officers.
That's correct. There were two items, two items of,
And are those two items that you just referenced in the record?
they are in the record, Your Honor.
find
They
it.
are in the record. They were attached to Mr. Brinson's 440 motion, which is consolidated with this appeal. I don't have the exact page numbers. I think it's around 270 or so. Those are in the record. They reveal that they were one of them was from 2005, 2006, and the other one was from 2020. So in existence at the time, they were presumably in the people's possession or deemed to be in the people's possession. So no reason why they shouldn't have turned those over.
I looked at the direct appeal information. I didn't focus on the 440. I'll go back and look at that. Thank you.
No problem. There are. And there was a fourth item to some more additional Rosario materials, and I don't know that those are in the record, but the Giglio materials are definitely in the record. So yeah, and it's under these circumstances, remittal is definitely not allowed, not warranted. This court has recently held in Hernandez. The First Department has held as well under these circumstances that there's no remittal required. The remedy is the dismissal of the indictment. I'd like to turn now, if I could, to the weight of the evidence argument, and that the jury was definitely not justified in finding him guilty beyond a reasonable doubt. This was obviously a close case. The first jury was hung and led to a mistrial. The second jury took a few days to come to their conclusion, but the automobile presumption is out under the jury instructions in this case, so the jury had to find him under dominion and control or actual possession theory. And there's plainly conflicting inferences on that ground. To start, the people don't dispute the fact that the gun could not have been where it was ultimately found during the chase. So it had to be put there within the seconds after the crash, and the police descended on the vehicle. And the question is, how did it get there? Mr. Brinson immediately jumped out of the car, started running. His co-defendant, the passenger in the car, took a little bit longer.
Well, the idea that was it the driver jumped out of the car immediately?
Correct.
Yeah, and so are you arguing that because he immediately jumped out of the car, he would not have had an opportunity to place the gun in that position?
Yes, Your Honor.
As opposed to immediately placing the gun in that position and then jumping out of the car?
That's correct. Yeah, I just don't think there was enough time for him. If he was actually possessing the weapon, and we know it couldn't have been there during the chase. So I don't know how it would have had to have gotten there by somebody putting it there. And the driver immediately exited the car and just started running. So I don't know how he would have had time. I mean, it was literally a matter of seconds. The other passenger was attempting to get out of the car, reaching for a second gun that he had in his waistband. So it's equally plausible, if not more likely, that the gun was put there by the passenger, not Mr. Brinson. And I think that, it's fair to say that the jury was not justified in finding him guilty under those circumstances when you have, if they can't prove that he's probably guilty, they'd have to prove beyond a reasonable doubt. And I think that existed in this case. So for those two reasons, I mean, the indictment should be dismissed for the 30-30 violation, and if not on those grounds, against the weight of the evidence. With respect to the remaining arguments, unless the court has any questions or wants me to discuss any of the evidentiary problems or ineffective assistance of counsel, I will rest in my brief for the remaining
Thank you,
arguments.
counsel.
Thank you.
Good morning, Your Honors. Ryan Ash for the people. Regarding point one, as to the court's response to the defendant's 30-30 motion, it's the people's position that the court decided the motion on improper grounds, essentially treating it as a 245.80 motion, or, on other grounds that aren't related necessarily to the discovery statute, like Brady and Rosario. And that explains why the court was making these inquiries and also oral decision on the record that didn't mention a due diligence, reasonable efforts determination, and also didn't reference a time calculation. And this case, to be perfectly frank, I'm not arguing that the procedure followed by all parties in this case, it should be followed in every other case. The timeline here is crunched. There's the people are entitled to request an adjournment to respond to a 30-30 motion or discovery motion where, they're entitled to a reasonable time to respond. This motion does come in the day before trial. So the people certainly would have been entitled to an adjournment if they had asked for one. That is not particularly I think that's probably what should have happened so that we can get motion papers on the record. And it's certainly would have been required for the court to grant that motion if the people had asked for it, or if the court had determined that the oral response wasn't a sufficient form of response. And that's my argument about, I don't want to concede that the people's response here was sufficient, because my argument is that we need remittal so that they can submit a sufficient response. But certainly the form of their response was treated as sufficient. And the people would have been entitled to an adjournment to respond if the court had decided that an oral response wasn't sufficient. And here,
So let me just see if I understand what you just argued.
right,
You're saying that the response, the oral response to the 30-30 motion, the motion that was on papers by the defendant, the oral response was adequate, is part of your argument, but that the prosecution could have asked for time to respond in writing, but the oral response was adequate?
well, my response there is that this is I'm just not trying to use the word response so much. This is in response to the argument on appeal that the motion should have been granted summarily, because the people essentially didn't file a response to the motion.
And that's pretty clear in the record, right? There's no written response.
There is no written
to the written motion.
right.
Okay. And so that's not even disputed here.
Right.
But what you're saying is the oral response to the written motion was sufficient. That's your position.
Right. I don't want to be making this distinction without a difference, and just repeating myself. But my argument essentially is that the defendant wasn't entitled to a summary grant of its motion because the people didn't file a written response. I think there's a difference here between the people submitting an oral response that's treated as a response to the motion versus the court treating it as in, or at least this court treating it as in, we're going to pretend like the people completely didn't file any sort of response here. Therefore, the motion's automatically granted. And I think that,
So you're saying that the people provided an oral response, which was partially what they wanted to submit, but they weren't given an opportunity to submit further argument?
yes, I understand the confusion here. And I think the confusion is only compounded by the trial court here, deciding this motion under the wrong standard.
But let's stay focused on what the obligation of the prosecutor was.
Yes,
At the time the motion was presented to the court for decision.
right.
Right? We do know we have a 30-30 written motion before the court. We do know that the court was hearing that motion. And your position is that the prosecution made a partial response. They didn't completely waive putting in a response.
My answer would be the people responded to the extent that the grounds of the court was deciding the motion on. Because from the beginning of the argument, there's this discussion about a witness list.
Prosecution know what the grounds the court is deciding the motion on before the argument and issues joined on the argument.
Because there's things in the record here before I think there's only a single statement that you could construe by the prosecution as being a 30-30 discovery motion argument. And that's essentially when he says, I just became aware of this. Everything else is going towards, and I think even by the defendant, I think everything else in this motion argument is going towards Brady and Rosario. And I think that ultimately that's what the court was considered about. And then I agree that it's a little hard to go backwards in time and justify the people's response as per scope. But ultimately, when we do get to the end of the motion argument, the court doesn't say, well, the people didn't respond at all to these 30-30 or 245 arguments. The court essentially understood incorrectly that this was going to be a Brady, Rosario discovery sanctions motion. And I think the reason I'm asking for a remittal is for everybody to get on the same page. The remedy granted to the defendant here is dismissal. And I think that what is deserving of this record is a full motion argument here, where we don't have to look at this really, really compressed time frame and think about who was entitled to an adjournment or whether or not the motion response was, in the proper form. If it was in the proper form, then how do we take that to mean the people are conceding issues they didn't bring up and those sort of things? When I think the clear answer supported by the law in cases where the court decides a motion under the wrong grounds, here, I think it was Brady, Rosario, and discovery.
Mr. Ash, nowadays too, don't forget, this is all pre-amendment for the 245-20 discovery obligation. So we have a case called People v. Chase Walker. And there the court set forth a very clear standard, that is, there's a relevancy prong and there's a possessory prong to the people's obligation to do initial disclosure.
Right.
In Radford, where your office was on that case, Radford, we specifically described how initial discovery, that is, that which is made pursuant to the 245.10. So point 10 is the time frame that is dependent on whether or not the defendant is incarcerated or not. So it's that initial discovery and only initial discovery within that time frame that gets the defendant 30-30 relief. Otherwise, according to Radford, it's prejudicial analysis and sanctions. So the question I've got for you ultimately is, did you have a chance in this case to argue the possessory prong within the time frame for initial discovery and the relevancy prong within the time frame for initial discovery? Because it's only initial discovery that relates to the dismissal under 30-30. So that's my question. Was that aired out, so to speak? There was a lot to that, Mr.
I think I do understand it. I'm familiar with the Radford case and the idea that the 30-30 is triggered by the initial disclosure, not necessarily materials that come into our possession after that period. My short answer is that I don't think that was developed on this record. I don't think that the people had essentially a reasonable opportunity to do that on the day, from the day before trial to trial. And that's sort of my argument, is that if the people were clued in to the idea that this is going to be a due diligence, reasonable efforts motion, they certainly should have, and I think I'm arguing that they would have asked for.
Would you agree with this? Clearly, the best practice for the prosecution would have been at the time of the argument to say, Your Honor, we need some time to prepare a written response to 3030. We just got it. Could we have a reasonable amount of time to respond and before the court rules on this? That would have been better practice, right?
I think I won't get in any trouble by saying I think that would be better practice.
Okay.
Something I want to bring to the court's attention too is that I don't want to act like I'm not conceding and ground or not trying to admit that my position does have, some flaws, and is asking you to take some asking you to take into account that yes, the motion was made on the eve of trial, and the people, there's an argument that I wouldn't be necessarily comfortable making here, that the people could have showed up to trial and said the motion is returnable today, therefore it's untimely, therefore it should be denied as a matter of law. And I think whether or not that's supported by the current case law for the timing of discovery motions, I think is.
Did the timing of the motion have something to do with how much time the defense counsel had in terms of getting the documents?
Your Honor, and that's exactly why I'm not making that argument necessarily. So I think here, ultimately, what is due to this case and what this case deserves is a look at what actually the reasonable efforts were that went into the initial disclosure, as Justice Kern is trying to get me to talk about. The one partial answer to your question too is that there were multiple prosecutors on this case, and so the prosecutor here at argument didn't know about the reasonable efforts and due diligence necessarily that went into the initial disclosure. So about whether or not this report was possessed and what efforts they did for the initial disclosure and the initial COC. This is a separate prosecutor who a year later is doing these supplemental COCs. So I think in order to, I don't know the answer to your question. Well, your question was about is it on the record? So my answer would be no. But in order to answer the actual facts of your question, I think that's when remittal is required. And I think I'm comfortable submitting on the weight of the evidence and the other.
Thank you, counsel.
Thank you.
Case 899 in the matter of Shayna Riley versus Turner. Proceed, counsel.
Thank you, Your Honor. Andrew DePasquale, on behalf of Ms. Riley, the appellant. Our central argument is that the family court analyzed the father's intent at the wrong time. There was a lot of focus on when the father entered the church, he was described as having a cheerful demeanor. But then after he entered the church, he approaches my client, the mother, and they have what ends up being a tense conversation. My client says to him, "Where were you yesterday?" referring to the child's first birthday party. And she says, "You should have been there." And they have a back and forth. And then it's after that that the physical confrontation happens. And our central point is that there wasn't much of any analysis about what was the father's intent at that time. There was 4 witnesses that testified on my client's behalf, including herself. Just the father testified on his own behalf. One of the witnesses was in the church choir, so she was positioned in the front of the church and she was facing out towards the congregation. So she saw everything, and she described the father as shoving the mother. I know respondent in her brief, I respectfully disagree that it's a contradiction to say that the
that the witness said was pushed, or he pushed her. Because on cross-examination, she was pressed on the details of the term shove. And she used the word push. So I think that those terms are synonymous. I think it's important to note that shove is obviously the word that's used in the definition of harassment in the second degree. So when it came to the court's decision, that wasn't touched on much at all. It was about 3 sentences, the analysis. And there was a general acknowledgement or a general mention of witness credibility, just about the basics of the story, but there was nothing in detail about that moment when things became tense between the mother and the father. And I think that when you have a witness, especially a witness that member of the church choir did not know either party personally, so you have a disinterested witness who is talking about conduct that heavily implies harassment in the second degree and disorderly conduct. I think that that needs to be discussed in the decision. And also, the way that the conversation ended prior to the incident getting physical, my client says, get out of my face, go sit down. Right. And that's when the physical confrontation happens. And I think the way the decision was written, it almost implies that the father was provoked, but that's not a justification for escalating the situation instead of de-escalating it. So I think that this behavior went far beyond just an intent to have access to his child. And I think that it constitutes harassment in the second degree and disorderly conduct. I'd ask this court to reverse that decision.
We'll take a look at it, Counsel. Thank you.
Good morning, Your Honors. May it please the court, Vera Vinkova for respondent Jason Turner. I would ask the court to affirm the decision. I think that it does not fit the definition of any of the crimes that are alleged because each of those crimes require the intent. And my client has testified repeatedly that his intent was to obtain physically obtain his child. Both parties and witnesses have testified that they were tussling with a child. So both parties were engaging in really not what one would consider an appropriate conduct when transferring a child from one parent to the other. That was their regular exchange place of the child. And Miss Riley's volatile personality comes clear through the record, right? She was unhappy with him that he didn't show up for the party, and she started picking.
You're talking about the party the day before?
The party the day before, yes.
Which was a birthday party for the child.
Correct.
Yeah.
And my client testified why he didn't feel comfortable coming there. And it wasn't during the trial so much so during every appearance before that, where the court could see that Miss Riley did not really follow court orders. She tried to avoid giving my client visitation with his daughter. And it was she who argued with the court. It was she who had outbursts. My client has repeatedly maintained cool in the courtroom. And all he wanted was to have his regularly scheduled visitation. Unfortunately, because Miss Riley was set on having a disagreement with him, they entered into a physical interaction, but it does not at any point imply any intent. And he clearly testified that he did not have the intent to alarm or harass her. His only intent was to have a visitation with his child. So unless the court has any questions, I would.
No further questions, Counsel. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. Maureen Poland from the Legal Aid Society of Rochester for the child. I would note that the trial court is very familiar with these parties. They had previously appeared before the court. They are before the trial court again right now. They have pending matters. So the court was familiar with the parties, with their demeanor, with their interactions. And I think that certainly informed the trial court's decision and assessment of credibility in this matter. And I would ask that the court affirm the trial court's orders. And unless there's any questions, I would rest on my brief.
Thank you, Counsel.
Thank you.
Case 900 and 901. Durka versus Fairport Pediatrics LLP. Counsel, can you hear us?
I can, Your Honor. I cannot see anyone right now, but I can see myself in the screen.
Well, do you want to make an adjustment? Maybe.
I don't know that there is, I'm unmuted and I have my video showing. I was able to see the entire panel. Oh, here I am. I can see everyone now. I thank you, Your Honor, for your patience.
Terrific. No problem. No problem at all, counsel. Thank you. Please proceed, counsel.
Good morning, Your Honors. James Special for Fairport Pediatrics. Now here we have Fairport. First of all, as soon as they got the complaint in this case, they did immediately take action to try to help plaintiff. And unfortunately, that hasn't worked too well for them. Because we could never find anything in the doctor's history, Dr. Misachowski, that would cause anyone any type of concern, even close. And the theory is essentially that we are somehow responsible for supervision of her mother. And that's assuming any of this happened, the mother.
Counselor, but you did, I mean, whether he had any history or not, and I think it's fairly clear he didn't have any prior history, but you still had an office policy that children weren't to be left in exam rooms with a provider without another person, a third party being in there.
Right. And
right. And isn't that policy in place to, among other things, to protect children?
Well, among other things, but I mean, because there was another person there, and the person, well, even looking at it, the mother is of course living still, but putting that aside, the mother was there. The mother was there, and she apparently left, and there's no allegation that she told anyone. I don't know.
Counsel, let me ask you this though. Just in terms of the facts, just so we understand the facts, right? That's what I'm getting into here.
Okay.
Is the mother was in the room at the beginning of the examination.
Yeah.
Right?
Yeah.
And that's part of what the point you're trying to make there.
Yeah.
Right. There's some evidence in the record that the mother was, I think, was occupied on her phone.
Yeah.
At the time.
Correct.
Okay. And may not have been paying close attention.
Yeah.
And there's an allegation that there was an abuse that took place at that time.
At that time, while she's in the room.
While she's in the room. But then the mother leaves.
That's plaintiff's testimony, yes.
And your position is mother never left during the whole examination?
Well, no. Well, my position is twofold. Even if she did, I don't see any basis how Fairport could be liable. Now, Dr. Misachowski, I don't represent him, but conceivably, sure, he could be. But my client, that policy was followed. Their policy literally was followed. It's up to the parents, of course, because the parent has legal and physical custody of the child at that moment. And I could not find any case anywhere. I don't know, it's always possible I missed something, but I don't think so, where there's liability in these circumstances where the parent has actual control, is actually in the room while the alleged assault is said to occur.
But in a motion such as this, don't we look to and deem the testimony offered by the opposition to the motion favorably?
Sure. So
and so that testimony, isn't that testimony that contradicts what you're arguing now, and that is that the mother was in the room the whole time?
No. So let's say it happened just as plaintiff said, and he asked the mother to leave. Why would I could see why you would get liability on him, maybe, but I don't see how that extends to me.
Well, we're not, in my mind, we're not talking about liability. It's whether there's a question of fact. And we've got some questions here, don't we? Because the plaintiff says he asked my mother to leave. And as a consequence, I was left alone in the room with him. And we know that the practice had a policy that providers are not supposed to be alone in the room. And he also testified that if I was ever left alone in a room for some reason, I'd get out, grab a nurse or someone else and bring that third party back into the room. Isn't all of that together a question of fact here?
No, I'm kind of, so we didn't leave her alone with the doctor. So knowing from Fairport, she's not even alleging that anyone from Fairport left her in the room. She's alleging that her mother left her in the room.
Was Dr. Michikowski, am I pronouncing that?
Yeah.
Close enough?
Yeah.
Yeah, okay, Dr. Michikowski, and I apologize if I'm not. Wasn't his status as a principal of Fairport? Wasn't he an owner?
Yeah, right. So
Does that make a difference? When you say that you weren't in the room,
well,
what hat was he wearing? And is that a fair question?
so it's actually kind of interesting because they try to compare him to a regular employee, but the fact that he's a principal, I think it helps me even more because like he's essentially like a lawyer would be, right? I mean, he can work by himself. There's no legal requirement that anyone has to supervise him like any of us. Like, I mean, what their theory basically is we had a duty to it would be like let's say my assistant, if you imposed a requirement that my assistant had to supervise me while I'm meeting with a client. It just makes no sense. So the fact that he's a part owner and there's no legal requirement in the first place for anyone to supervise him, and then on top of it, it's basically they're alleging that we had some duty to supervise how the mother was supervising plaintiff. They're not actually saying anyone from Fairport is failing to supervise her. They're saying that we failed to supervise her mother for some reason, and I could not find any case that's anything like that. And I would add, I don't see how in this particular case, where, I mean, obviously I know what the familiar summary judgment standard is. Here, I would almost say that's an unfair standard to apply in this case, and here's why. Not only is plaintiff's mother living, she testified that during the deposition, plaintiff did, that she was living with the mother at a time. So what they're saying is there's an eyewitness that has directly relevant evidence, could basically at least prove the case against the doctor and probably provide probable cause to the DA to actually charge him for this. But she's nowhere to be found. There's no affidavit from her.
Time out, Counsel. I'm going to interrupt you just to kind of bring us back to where I see you going again, but the questions started with. On this motion, following up on the presiding justice's question, don't you have to essentially accept the facts as represented by the plaintiff as true? Otherwise, so the way I read your motion papers was you were sort of fighting against that, but ultimately say, okay, let's assume everything the plaintiff said was true.
Sure.
The facts exactly that way. you would say that you still had a duty to protect her from that harm, correct? Which is why you devised a policy.
Actually,
Stone Park.
I think there's a reasonable basis to say no to that. And the reason I say that is because this is so much different. And I've done a lot of these CVA cases. This thing with usually the theory is the in loco parentis things, which you of course dealt with in many of these CVA cases. The whole idea is that the organization has a duty because they're standing in the place of the parents. Here, we're literally not standing in the place of the parents. It's her mother is there and they're saying, we're responsible for not your employee, but because the mother allegedly negligent supervisor.
You're losing me. I'm sorry to be so candid about it, but I thought you agreed that your client had a duty to protect the infant plaintiff here at the time from this type of abuse, which you accept as true for purposes of the motion. If you're now saying, and this is contrary to my understanding of your argument in your brief, that there is absolutely no duty as a matter of law, that's a whole different question. I thought you were founded on the idea that there was a duty, but you didn't breach it because this was not foreseeable conduct.
Well, okay, so it can go two different ways. So not foreseeable certainly is what I'm saying. That's one part of it.
I thought that was your argument.
Yeah, that's the big one. That's the primary one. But
Can we just stick with that one real quick?
Sure.
Because I know you want to go back to the duty argument,
Yeah.
but I understood, like Justice Smith did, your argument was primarily had to do with foreseeability. But then that question is, so is this harm foreseeable? That is, was it within the class of reasonably foreseeable hazards that the duty exists to prevent? Doesn't, getting back to what Justice Del Conte is, it doesn't the existence of the policy of having someone in the room with the physician, doesn't the existence of that policy infer at a minimum that this type of harm is foreseeable? Why have such a policy if it's entirely unforeseeable as a matter of law?
Okay, so I don't think I was following you the first time, but now I do. So my argument is that, and I say this because I'm following Nellen back, right? So the foreseeability, it's not that we can foresee if this rule is broken, something could happen, because anytime a rule is broken, something bad could happen. The thing that's not foreseeable to me is that he would actually do this and tell her to leave the room, because the prior conduct of the perpetrator, like in Nellenbeck and of course many other cases, it's the focus is always on the prior conduct of the perpetrator. And I think from Nellenbeck, it's quite clear that there has to be something in the perpetrator's history that would raise a suspicion, which here there's absolutely not.
You're saying the foreseeability issue boils down to it wasn't foreseeable by the practice.
Yes.
Your client.
Yes.
That he would ask the mother to leave the room.
Yeah.
That's the foreseeability issue that you're arguing today.
Right. Because to me, I mean, and Nellenbeck is the most recent Court of Appeals cases, so I think of that one first, where the focus is clearly on the prior conduct of the perpetrator. So, and here there's none. So that is my argument. In the nutshell, it's not foreseeable because there has to be the prior conduct. It can't be like the actual action renders it foreseeable. So that's because
in terms of prior conduct, you're talking about the practice wasn't aware of, had no force. There was no reason for them to foresee that he would ask her to leave the room because he never asked anybody else to leave the room.
Well, and I'd go further. I mean, there's never been any complaints about him other than minor billing stuff. There's there was no professional complaints to the Office of Professional Medical Conduct. No one has found anything that he's ever done anything wrong. And certainly nothing even that would raise suspicions about him doing something like this. So that is my foreseeability for notice argument, and another term for it, I suppose, is that there's no prior conduct here at all.
Counselor, just so I don't let this go without mentioning it to you, but this is summary judgment. You need to move on the basis of admissible evidence. As I understand the record, and this apparently was pointed out by the plaintiff's response to your statement of material facts, that in your motion papers, you failed to attach both segments of the practice manager's testimony. You only attached the first, and you completely failed to attach the doctor's testimony. As I understand your motion, it's the second segment of the practice administrator's testimony and the doctor's testimony that you rely on to show the absence of notice and foreseeability. Given the fact that you had the burden on the motion, isn't the absence of that evidence supporting your motion fatal?
Well, two things on that. No, because it was still submitted on the end, and this court, like the trial,
Submitted on the end. What do you mean?
It was submitted by plaintiff submitted the doctor's
in response to your motion.
Yeah,
but don't you need to carry the burden on your motion in your papers? You're not allowed to rely upon what the plaintiff subsequently submits to make to reach your burden, right?
Well, yeah, that was clearly just a filing error, though, and we note that. I mean, we did talk about his deposition testimony in the papers. It's just that when they went to get uploaded, for some reason, it didn't. I mean, that's a very technical defect, but you know what? The only testimony I need ultimately, I think, is from plaintiff herself, because there's, and this kind of goes back to what Justice Curran was saying as far as duty. I agree there's a duty, but the mother was in the room, so that fulfilled the duty. No one from Fairport, they're saying there should have been a nurse. Well, why would there be a nurse if her mother was there, and then her mother does something unexpected? How could anyone foresee that? I mean, parents go in the room all the time and there's no issue. And
I think we have that argument.
Sure.
Anything further?
I don't think so. If there are no other questions, thanks.
Thank you, counsel.
Good morning, Your Honor.
Proceed.
Thank you. Good morning. May it please the court. I'm representing the plaintiff in this case. The court correctly denied summary judgment on the negligence causes of action. I'd like to clarify some of the facts that were adduced. There were two assaults here. The plaintiff testified, and Your Honor, Judge Whalen, we have to take the plaintiff's testimony on its face on this motion. The plaintiff testified that at the time of the first assault, her mother was indeed in the room and she was looking at her phone, but the doctor was blocking the mother's ability to see what the doctor was doing to her at the time. He then...
Well, we don't, counsel, in fairness, we don't know that the doctor was blocking the mother's ability to see from the record, do we? I think what we know is, according to the plaintiff believed that the doctor was blocking the mother's ability.
Right.
From the plaintiff's point of view. We don't know that from the mother's point of view because that's not part of the record, right?
That's right. The plaintiff believed that her mother could not see what the doctor was doing at the time.
A slight clarification. Yeah.
Yes. Then the mother was asked to leave the room by the doctor, and that's when the second assault occurred. The argument that the mother is blameworthy here, all these arguments do not eliminate the questions of fact. The testimony here is that there was a policy. The defendants admitted that there was a policy that it was not proper. The doctor himself testified it was not proper to ever give a pediatrician to ever give a vaginal exam. And that's at pages 373 and 380 of the record. He also testified, and one of the justices pointed out, that if a parent or the nurse left the room, he'd leave and locate someone else. And that's at page 398 of the record. Ms. Soldi testified that it was a violation of a policy for a pediatrician to be left alone during an exam. And that's at pages 287 to 289 of the record. Defendant has made numerous arguments that this doctor could not be supervised by a nurse and that doctors and attorneys work frequently without supervision. I'd refer the court to page 280 of the record where Ms. Soldi is asked who during the time was responsible for supervising the doctor to ensure that he was not sexually abusing patients. Answer, Dr. M was a partner, is a partner, so he would not be supervised by anyone other than a parent who was in the room or a nurse who was with him. So in fact, there is an acknowledgement by defendant's witness that that type of supervision was necessary, even though he's a doctor. The argument, it's interesting, frankly, that the counsel was acknowledging the foreseeability issue in this case because the brief by defendant has argued, beginning at the main brief at 11 to 12, that cases that hold, quote, that prior knowledge of an individual's propensity to engage in criminal conduct isn't required to establish a claim for negligent supervision. In as much as there are situations where the conduct may be a reasonably foreseeable consequence of circumstances, is in conflict with Nellenbeck and is no longer valid law. And defendant cites Blanchard, which is a case from this court. Respectfully, this case does not deviate from new law. Nellenbeck was a case in which the plaintiff asserted one cause of action against the county, and it was negligent hiring, supervision, and retention of a county caseworker who assaulted a child. And in that case, the court held there was insufficient evidence of propensity, case dismissed. The negligent hiring and supervision and retention claim in this case was dismissed. Nellenbeck has no application to the remaining cases, and so to the extent the defendant argues repeatedly in the brief that foreseeability isn't relevant because there's no notice, I ask that the court reject it because it's misplaced. The arguments of Nellenbeck applied to the negligent hiring claim. The claim was dismissed. Plaintiff didn't appeal that claim. This does boil down to foreseeability. And in that regard, with respect to the violation of Fairport's policy by leaving the doctor alone with the child and the failure to supervise the doctor, I'd refer the court to the Second Department decision of JB versus Monroe Westbury. And in that case, it was a school district that was sued because a doctor was left alone with a child in violation of the policy. And the Second Department said a jury could reasonably conclude that the policy was intended to protect children and therefore making it foreseeable, and therefore there were questions of fact for a jury. The other claim that we had that the court sustained was the failure to supervise or safeguard the child when she was a patient there. And in this regard, I refer the court to this court's case in AB 511. It's another school case, but the facts there apply here. That in that case, this court said that notice of propensity, quote, was not required to establish a cause of action for negligent supervision of a student because, quote, such conduct may be a reasonably foreseeable consequence of the circumstances created by the defendant. The defendant's circumstances that they created were allowing a pediatrician in a position of authority to be left alone with a child without anyone else there. The arguments raised by defendant that the fact that the mother left the room made it the mother's decision to leave the child alone, and whether or not the mother should not have trusted a physician to do the right thing and not violate her child. Those were all questions of fact for a jury. They do nothing to eliminate questions of fact for a jury on the foreseeability issue. Unless the court has any further questions, I would rest on the brief.
No further questions, counsel. Thank you.
Thank you.
All right, calling next case numbers 902-903, Watney versus City of Buffalo. Okay, my list, okay, Mr. Matheson has submitted. Mr. Ryan, that means you're here on your own, sir. Go right ahead.
Good morning, Your Honors. May it please the court, John Ryan on behalf of the plaintiff appellant Kashia Gwathney. Your Honors, very simply, the court erred in not following this court's standards in Ellis, Regdos, and Portis with a similar factual situation where in Regdos and Portis, the court here found that there is an issue of fact regarding whether an officer acted with reckless due regard. And in Ellis, the court actually found as a matter of law that an officer in a similar situation did act with reckless due regard. Your Honors, the key facts here is the approach from behind. I think that in situations like this, it is necessary to have both lights and sirens. Otherwise, the drivers in front of the police vehicle can't even know they're coming. In this situation, we have not only contradicting testimony from the plaintiff and the officer, but also sworn statement from an uninterested witness that favors the plaintiff here.
The other principal issue here too is the testimony of Officer Kennedy that in order to proceed through that intersection, the policies of the department where you got to have both the lights and the siren engaged.
Yeah, absolutely, Your Honor. Right.
That's your position. We don't know whether the siren was engaged. There's some questions of fact here. He says it was, they say it wasn't.
Yeah, I would agree. And I'd even go a step further, right? Like we don't know whether or not the horn, right, the foghorn was engaged or the air horn, excuse me. The officer himself says he didn't engage the sirens that were in the center console that Officer Kennedy said you can engage and that car was equipped with, right? So we know for sure that the sirens that continue as the officer is driving were not engaged. The only question at this point is whether or not he was actually hitting that air horn, right? So it's even a step further, I think, than that. You know, and Your Honors, it seems to me by the lack of questions and everything else that you understand my argument, you understand the comparable cases. The only thing that I would just say to take a step further with this is really looking at Ellis, okay? And I took some time, looked over the different details, everything else like that. And you have this video, right? If there were pedestrians like there were on every other side of this street, Walden Avenue is a main thoroughfare on the east side of Buffalo. If there were pedestrians on Walden and Ruland, this would have been Ellis, right? T-bone collision off into the pylon of a storefront that's right there. If there's pedestrians there, it's the same exact amount of damage. And then I would also point to the fact that in Ellis, we actually have a situation where the police officer actually started to brake at least 2 seconds before that collision. In our collision, that officer did not brake until between 0 and 1 second, if it was a brake, right? Based on the AIU Officer Kennedy's testimony, we know that 5 seconds before it was 50 miles per hour, 4 seconds before it's 51, 3 seconds before it's 51, 2 seconds before it's 51, 1 second before it's 50, 1 millisecond it's 40, right? And we haven't gotten into expert disclosure or anything like that, but I think we can kind of draw from that 10-second deceleration right there is potentially just because the actual contact happened, right? If you're looking at that video, you cannot see that officer's vehicle enter its brake lights or brake, right? And so, Your Honors, like I said, I think Portis and Rigdos put us over the top as far as this being an issue of fact. I think that this is almost directly akin to Ellis, where this court again found reckless due regard as a matter of law on the behalf of the officer. We did not cross move. However, this court does have the ability to search the record and settle that issue under CPLR 3212B. This court actually did a similar thing in the Kabir v. County of Monroe case when it was addressing whether or not following too closely is a negligent standard or reckless due regard standard. That's discretionary to you, but I am putting that out there. And unless the court has any further questions, it seems like my argument is understood on this case.
No questions, counsel.
Thank you, Your Honor.
Case 906, in the matter of Ragnar B.
Hello, Your Honors.
Hello, counsel. Can you hear us all right?
I can hear you fine. Can you hear me, Your Honor?
Very good. Terrific. Thank you, counsel. Please proceed.
Good morning, John Rowley for respondent appellant Gary Bewley Newmar. I submit this is a particularly important case. This is an allocution gone wrong, which happens. The family court allocutions happen every day. They happen in criminal court as well. This missed the mark on all important.
Allocute on what point, Mr. Rowley?
There was a permanent neglect trial going on. Off the record, apparently the father's counsel told the judge, we want to admit. On the record.
The allocution is vis-a-vis the father's consent to the permanent neglect.
That's right. So
that's the issue you are raising here on appeal.
That's correct.
There has been a notice of appeal of which we have taken judicial notice from a later order.
Correct.
Which has to do with a motion to vacate vis-a-vis the consent issue.
Right.
In that situation, Mr. Rowley, it may be that that's a subsequent order.
Correct.
That might, these are cavalier words, moot out this appeal. And then we would look at the consent issue down the road, assuming that's appealable, et cetera, et cetera. But the subsequent order, just so you know, we know there's a notice of appeal from it. Doesn't that sort of say that we should not review this case right now?
I don't, it makes no difference to me. Let me just say that what happened in that case is disturbing. It needs to be reviewed on appeal. If you folks want me to come back in 6 months, I'll come back in 6 months. That was really a protective filing because it's a little hard to figure out procedurally which way I needed to proceed. So I proceeded in both courts.
Because unless you got the consent set aside, we'd be staring at an issue that was consented and therefore there'd be no agreement because your client had consented to it. So in a way, you say you're ambivalent to it, but in a way you kind of need the later order for us to take a look at it, don't you?
Yeah, that was the thinking. I was afraid you would say, go back. And I said, well, I'll go back, but I'm here too. Tell me to go back? Want me to make my argument?
Counsel, make your argument.
I'll make my argument. So an allocution. Allocution, first you say to the client, I understand you want to consent to the permanent neglect. Then you say that the elements of a voluntary, intelligent, and knowing admission. Then you have them admit to the elements. None of those things happened. None of them happened. And then place the father under oath. And then in this case, that all happened. The father did not admit to any of those elements. The closest it came was when the father said, well, you're right, I didn't go to enough visitations. He explained later he didn't go to them because he was working, because he doesn't get any money from DSS, and he's trying to get his house fixed up so he can have visits. The judge said, and as you see from the record, I quote, well, counsel, I don't think this is enough for a finding. DSS says, I think you're right. The judge says, well, I'm going to find permanent neglect. That was not a legal error. That was not a factual error. That was an error of judgment. And it's a disturbing error. And what I would submit is that this is a good case to remind the court what an allocution should look like, how they're done. They're straightforward, black letter law. This is a case for that. Thank you.
We'll take a look at that, counsel. Thank you. Counsel, proceed.
Okay, Your Honors. I agree with this statement in court. I believe that that issue really is moot and that we can deal with that another day. I would like to say, though, I think that—
Counsel?
Yes.
Hold on a second. Counsel, could you please come up here? Sure. Yeah.
Oh, wait, listen to him.
Yeah, I'd like you to not leave until the argument's over.
I'm sorry. Honestly, I'm going to sit back.
Thank you. My apologies, counsel. Proceed.
No problem, Your Honors. I agree with the statement to the court that on that issue of the elocution as it's been presented, I believe that is moot and we can maybe face that issue down the road. The only thing I would like to add is I think there there was a disturbing mischaracterization of what the judge said. When the judge stated, "We are not done yet," what the judge was referring to was the fact that we still have a disposition to deal with this matter. That concludes the fact finding. So the judge was not stating we don't have enough here. So I think that was mischaracterized. For what it's worth, I would like to just briefly then address the ineffective assistance of counsel argument that is made. My argument would be that not only did the counsel for the father proceed in a way that was very legitimate, he proceeded in the only way he could. He did not want to have his client testify at the fact-finding proceeding in the permanency neglect. It wouldn't have made any sense. The facts in this particular case on that issue were the same as with respect to the older brother. And in fact, this court stated in matter of Aaron 10 days ago that the department exercised diligent efforts. And on top of that, the father was uncooperative throughout the whole process. In addition to that, at the fact-finding proceeding, there had already been the testimony of a witness on the part of the department, Ms. Dursel, who basically stated once again that the father did not engage consistently in mental health, never engaged in domestic violence services, did not learn anything from parenting classes, did not even progress from unsupervised to intermittent visitation, did not progress from supervised to intermittent visitation, let alone clinical visitation. So there was a great risk to having the counsel for the father put him on at the fact finding, because again, he's kind of a live wire, and he was just going to do what he was going to do was destroy his credibility even more. So he made the calculation. That's not going to help us anywhere. Let's get to disposition. Let's try to have him testify enough on what's going on more recently to try to come up with a suspended judgment. Now, that again did not work out very well either, because at the disposition, then when the father did have the chance to speak, he said that my child's best interests are irrelevant. My priorities are number one, work. Number one, making money, and then the kids come afterwards. And finally, which really precludes him ever having a return of this child, my client, in his care, he said, I don't want unsupervised time. He said, basically, not basically, this is a quote, "You may want me, department, to have unsupervised time, but I will not take it. If he can't have unsupervised time, there can't be a return to him. It's time enough that my client gets permanency in the pre-adoptive home where his older brother lives also, and a loving foster mother." And with that, then I'll rest on my brief, Your Honors.
Thank you, counsel.
Thank you.
Case 907, Robert L. versus Holland Central School District.
May it please the court, counsel. Craig Bernhardt appearing on behalf of the plaintiff R.L. From Herman Law Firm. Your Honors, this Child Victims Act case involves a situation where from September to December of 1979, plaintiff R.L. was sexually abused by his math teacher, Carl Penzel, at the Holland Central School District. Prior to the last time that he was abused, the school district knew or should have known of facts and circumstances that Penzel posed a danger to his students. This record is over 2,500 pages, and if the court would indulge me, my legal arguments are premised upon some very specific facts that are in the record, and I would like to cite to those, if I may, using my time for a couple of moments. In the record, page 1678 to 1691. This is testimony from another plaintiff, T.Y.
T.Y. testified that his abuse was in 1978, which is a year predating RL in this case. He testified that the first abuse was in his classroom between classes. Door was shut. He and the perpetrator were alone in the class where the perpetrator performed a pain tolerance test on him, squeezing his testicles. He testified that that occurred no less than 10 times, multiple times a week over the course of several weeks, always in the classroom, in between classes, or immediately at the end of the day when everyone else was in the hall gathering their belongings. He then testified that after those 10 instances, it elevated to something more. It became the perpetrator putting his tongue in T.Y.'s mouth and having T.Y. fondle him again in the classroom, in between classes, and at the end of the day while people were in the hall gathering their belongings. T.Y. testified that that occurred no less than 24 times. So we have 34 incidents by his count in 1978 between classes when students were in the hallway gathering belongings or changing classes. He testified.
Did T.Y. bring this to the attention of any of the school personnel?
He did not. He testified at those pages in the record that the pain test, when the pain test occurred on those 10 occasions, there were always people nearby in the hallway and near the room. He recalls walking out of the room after these 34 incidents occurring and being embarrassed and awkward because other teachers were all standing there. The tongue in the mouth.
Just so we're clear though, he was embarrassed and feeling awkward, but because other people were in the hallway, none of those people were in the room and witnessed what went on, nor did he report to any of those people what went on.
Correct.
Okay.
Okay. He testified this happened so many times and it got so frequent, again, over a couple dozen times. At page 1724 of the record, he said the district should have known because he was alone in the room with the perp over and over and over with staff in the hallway, and it wasn't a secret thing. It was very dangerous and it was going on in broad daylight. That's page 1724. Now, EU, another plaintiff in these cases, testified he was abused between 77 and 81. So the abuse from 77 to 79 would have been 2 full years prior to the plaintiff in this case. He testified that in 6th grade, EU, this is the record, page 1025 to 1071, in 6th grade, 1978 to 1979, he was alone in the gym locker room with the perpetrator, a math teacher, in between classes, being fondled, having the pain tolerance test performed. They heard someone coming, so he stopped, and the gym teacher walked in and saw the two of them in there alone together. A math teacher with a student in the locker room alone in between classes. He also testified that he was babysat by the perpetrator between 5th and 7th grade. He testified that in 1979, he was babysat no less than once a month, and he testified that on 2 occasions, 2 other teachers came to his house, Teacher Greco and Teacher Mao, 1 month apart. Again, we're in 1979, so if you're giving me every reasonable inference, it's at or before the time that my client was abused. And he defined them, his present sense impression at the time was that these were welfare checks. In fact, Mao, Teacher Mao, when he came, said, "Is everything all right?" So we have 2 teachers that came to visit while the perpetrator was babysitting a male student. EU testified at the record, page 1158, he was abused at least 20 times during this time period. He also testified that in 1979 to 1980, he was driven off school grounds by the perpetrator during classes. During classes, the perpetrator would take him out, put him in his car, and drive him away, and that happened no less than 6 times in the middle of the school day. Now, we move into a subsample of 5 teachers that were deposed in this case, and what's important is not only what they've said, but what they haven't said. We have Leonard Greco. At page 435 to 480 of the record, Teacher Greco testified There was no training on sexual abuse at Holland Central School prior to 1981 when the perpetrator left. He testified that the perpetrator, he considered him to be immature and flamboyant. Teachers, this is extremely important. Leonard Grieco testified, teachers were supposed to be in the hallways in between classes watching students. Mind you, TY was abused no less than 34 times in between classes with the door shut and the perp alone with him in the room. Exiting after minutes, he testified the abuse lasted minutes in between classes, and the two of them would exit the room and other teachers are there. The reasonable inference we can draw is that other teachers knew that the perpetrator was in that classroom alone with students in between classes. When teacher Grieco testified, teachers were supposed to be in the hallways watching.
And the thing is too, it's the same student. It's not other students. It's not like he's giving direction on a math problem or something like that. Student X, and then the next day it's student Y. It seems to be the same EU person or TY that's being.
TY.
They should know, the teacher should know that this one student is receiving, well, I don't want to say receiving, but it is in there alone with the teacher. And it's not a situation where they're giving, maybe not giving extra help, where it's only the one student, it's not others.
Yeah, it's not like he's being asked to stay after school for extracurricular activities or help. I mean, a teacher who's supposed to be in the hallway watching students during this time is spending minutes alone behind a closed door, abusing TY no less than 34 times. And I think,
and shouldn't these other teachers be aware of that? Maybe bring it to either his attention or others' attention. Why is this teacher alone with this TY student so many times?
Certainly, I think a reasonably prudent parent might inquire, what's going on? Are you in trouble?
Isn't that the standard we should be reviewing here? Reasonable parent?
Yes, sir. Yes, it is, Judge.
So you're not arguing that the teachers that were required to be in the hallway for a particular purpose, and that is supervision. I presume, hallways are in change of class, they're crowded, and that's where if there's going to be, kids acting up, you want to have, teacher's presence there to kind of stop that, right? So assuming that that's the reason, you're not arguing that those teachers, in seeing or paying attention and knowing, or should have known, that the teacher was in the room with the plaintiff those many occasions. You're not suggesting that they should have known what was happening inside the classroom. Rather, what I think I hear you arguing is that was enough of a red flag for those teachers who know that the policy is you don't let the teachers shouldn't be alone with children, students, in a classroom or anywhere else. If that's the policy, or if that's the understanding, then they should be saying something.
100%.
That's what you're saying. That's your argument. Not that they should know what's happening in there.
100%. I think that based on that conduct, someone should be asking some questions, conducting an investigation. Why, when he is supposed to be out here in the hall supervising students, is he alone for several minutes in between classes with a door closed with a student? The same student 34 times over the course of 9 to 10 months.
I think we understand that argument.
Okay. And then Judge Grieco also testified that he was aware that the perpetrator was buying things for students. He was aware that he was taking students to out-of-town activities, sporting events. He was aware that the perpetrator was babysitting other students. There is evidence that he knew that the perpetrator was driving EU off school grounds during the day. Now, the reason that becomes important is because if we get to David Mills, he testified at page 521 of the record, he was a teacher, it would be inappropriate to take students off premises. You could be a student's friend, but not friendly, right? So he, a teacher at the time, a colleague of Grieco, says it would be inappropriate to take students off premises. Grieco knew it was happening, didn't do anything about it. And this is also important with respect to another teacher, Mary Bierfeld. She testified at page 2199 of the record. She recalls no policies and procedures on sexual abuse reporting or prevention. At 2206 of the record, she testified the perpetrator was immature and attention-seeking. At 2213 to 2215 of the record, she testified, if I knew that the perpetrator was taking kids out of school, I might have asked, what are you doing? She said, if I knew a teacher was taking students on overnight trips, I would have wanted more information. She was a colleague at the time. Now, she didn't know he was doing those things, but she said, if I had, this is what I would have done. Asked some questions and wanted more information. Rico knew. He didn't do anything about it. And Maureen Mullen, math teacher at page 555 of the record, never received any instructions on what to do if she suspected a child's being sexually abused. And at page 569 of the record, she testified she saw the perpetrator on multiple occasions take students in his car after school and drive them off school grounds and thought, oh boy, that could be a problem or a real issue. Now, she referred to if an accident happened or liability, but she was still armed with this type of knowledge and did nothing about it, despite the fact she thought it could be problematic. Brings me to two final points on facts. We have two former students, Margaret Fight, 2300 to 2311 of the record on appeal, says in 7th or 8th grade, which would have been 79 to 80 or 80 to 81, she heard the perp was in trouble because he had taken a bunch of students to a hockey game and heard that students were coming out of a closet one by one and he was feeling their junk. This was not whispered about. It was common knowledge. Her testimony. Everybody knew about it. So in essence, we have a situation where information was being spread throughout the entire 7th or 8th grade student body, yet no adult charged with supervising these children apparently picked up on it. Question of fact. The other student, Corinne Gallagher, 2239 to 2243 of the record, 77 to 78. Again, predating the plaintiff RL in this case by 2 years. She stayed after school numerous times with the perpetrator, and she was called one of Penzel's pets. These children that were favored by him had a name, Penzel's pets. She was smacked in the butt by him every time she walked out of the room. And at 2257 to 2267, she said that in 1977 to 1979, again, 2 years prior to RL in this case, she realized the perpetrator liked boys because information was spreading that he was going into the locker room and fondling young boys. Inspecting their junk is the terminology that she used.
Counsel, you should begin to wrap up.
Okay, so Your Honor, first and foremost, as far as the legal arguments are concerned, my position is that the defendant failed to establish their burden, and it never should have shifted to the plaintiff to begin with. These facts in and of themselves raise issues of fact that they failed to overcome. They submitted no policies and procedures. Their corporate representative testified he's not aware of any policies and procedures that were in place. He said that there are boundaries that are not to be crossed, staying in a hotel room, babysitting. He knows they're inappropriate now and has no reason to believe they weren't inappropriate then. So there's more than enough information that they did not meet their burden. If they did, my suggestion is that all of these facts raise an issue of fact. And with respect to our expert, I submit that it was error to preclude our expert. They've made this sort of making, I think, a mountain out of a molehill on the 1973 amendment of the Social Services Law. Our expert testified at voir dire. She relied on that in part. She relied on the 1978 resource packet that was handed down to every educational institution in the state in part. She was an educator. She's been since 1969, taught here in New York between 73 and 75 when that act passed. She had her training. Her credentials are what they are. I think we'd be hard pressed to find a more qualified expert. Any objection, I think, should have gone to the weight to be afforded her testimony rather than its admissibility. She didn't just simply rely on the 1973 amendment. She also relied on the fact that there were no policies and procedures, yet there should have been. She relied on all the deposition testimony, which shows that these red flags that she had been taught in the 1970s should have been reacted to. Absent any questions, Your Honor?
No questions, counsel. Thank you.
Thank you.
May it please the court, Brian Melber here for the respondent, Holland Central School District. With regard to all the facts that were recited by the appellant, all 5 of those teachers were deposed in full, and none of them indicated that there was any fact that came to their attention that gave them concern, suspicion, or raised any red flag about whether or not Carl Penzel was doing anything inappropriate or was a risk of sexually abusing any student in that school. And if you listen carefully to the recitation of the facts that we just heard, you see why. The fact is that nothing that, I think we heard it right at the end of counsel's presentation, inappropriate now and inappropriate then. This was 1979. December 1979 is the latest date of this abuse. At that time, there was a much different awareness about the risk of teachers sexually assaulting students in schools, certainly different than there is in 2025, different than there was even 25 years ago in 2001 when New York
Are
State.
you basically saying that back in 79, a reasonable parent wouldn't have exercised any furtherance?
That's exactly right, Judge. Based on what these teachers saw and what they knew, none of them thought there was any cause for concern. None of them thought there was any reason to inquire or investigate further. And we know for a fact that the actual parents of the students were giving permission for Mr. Penzel, who turned out later to be the abuser. They were giving permission to their sons to take overnight trips with him, to go to the boys club and have and be supervised him alone at the boys club for sporting activities, that they were having him babysit in their homes. This is what the actual parents were doing, who are in a position to observe Mr. Penzel's conduct and demeanor and how he acted for these boys. And in 1978 and 1979, there was nothing untoward about a teacher. We heard, and this is just a misstatement. There was no policy, practice, or belief or understanding among the teachers at this school or any school in New York State in 1978 and 1979 that it was inappropriate, risky, or even against any policy to be alone with a student, whether it's in the classroom, whether it's in the gym. The teachers were asked about that situation specifically, and they all said that that did not raise any cause for alarm. And not only was there no actual notice about this abuse to the school, there was no constructive notice. You can't find it in the being driven home after school, normal practice in 1979. It seems surprising now, judges, and I understand that, but it is critically important when we're talking about the reasonable care of this school district that we go back to what was known and understood in 1978 and 1979. And that's why the status and the preclusion of the expert opinion by the plaintiff's chosen expert is so critical in this case. Remember, procedurally, here's how this motion came about. After the close of all discovery and after plaintiff had offered this same expert in one of the companion cases, this is a group of 8 cases, all of students at the same district or in and around the same time period with the same abusive teacher.
So you're saying that basically back in 1979, there's no question of fact that any of this was improper?
That's exactly right, Judge. When you examine each and every allegation, every fact that plaintiff was able to marshal out of this record, and we understand and we accept that it's our burden.
You're saying there's no duty of the district to supervise this teacher or the students?
No, there is. The school, the district's duty through its staff and teachers is to do what a reasonably prudent person, knowing what they knew and understood then, would do. And that is what happened here. There was no failure to meet that duty based on what was understood at the time.
Wouldn't that be a question for the jury then to decide?
No, Judge, there still has to be some fact, some factual basis, some materially disputed fact, which, if true, would give rise to a concern, a red flag, or a suspicion on behalf of a reasonably prudent teacher or school district. And we just don't have that here. And we know that because Dr. Kreiser, the plaintiff's expert, reviewed all of the testimony in the record, reviewed all of the information, discovery, and disclosure. And then on the eve of trial, they served an expert disclosure from Dr. Kreiser. And it was only then that we brought this motion. And the motion was twofold. It was to preclude Dr. Kreiser as an expert and then to move for summary judgment. And the plaintiffs chose to advance the same expert who Justice Chimes, the trial court, had previously found had issued an opinion on, we call this the standard of care. In other words, what would a reasonable school district and teachers know and believe and understand at that time? On the standard of care, Dr. Kreiser's opinion had already been ruled by the same judge to have lacked foundation and to be precluded. And they brought the same, essentially the same. It was slightly amended, modified, but essentially the same position and the same foundation. And that foundation was the linchpin of it, was the 1972 Child Protective Services Act, New York state legislation that had to do with abused children. And there's a definition in that act. And this court has issued 2 recent rulings that discuss the meaning of that statute. The definition of abused child in that act is someone who's a child who's being abused by a parent or someone in the same legal position as the parent. And that is not, this court has held, that is not the school in loco parentis. A teacher abusing a child sexually was not contemplated. It wasn't dreamt of in the enactment of that 1972 law. And this court held in the Sully case that was the case, that the definition of abused child contemplated abuse by a parent or essentially a guardian, a foster parent.
That's what Judge Time said. Basically, you're misreading this and you're basing your opinion based upon.
That's what Judge Time said?
Right.
And
that's why she basically, in an eliminating motion, precluded the expert testimony.
Absolutely, Judge. And then I'll say first, Judge Chimes found that, this court found that in the Solly case, and then this court revisited that question in a slightly different way in the LG 70 case that's cited in plaintiff's reply. And there was a dissent in that case that points out that the majority analysis, Judge Whalen, you were on that dissent. There was a dissent in that case that pointed out that the analysis, the majority analysis in LG 70 is counter to a court of appeals case that holds in line with Solly. And so we'd argue that's the law. It comes from the Court of Appeals and this court. It's controlling. That means that Justice Chimes' decision to preclude the plaintiff's expert was correct. And without an expert looking at the evidence and saying in 1978 and 1979, here are the things that would raise a red flag. Here are the things that would give a school district constructive notice of a risk that this teacher, Carl Penzel, would abuse children sexually, then the absence of that is how we meet our burden. And the plaintiff spends a lot of time in the briefing arguing that we didn't meet our initial burden as the movement. I disagree.
What would you say to, I think the argument made by your opponent was that the court improperly shifted the burden to their side?
Yeah, I don't think that's the case. I think that the plaintiff is attempting to do that in the briefing. Our burden as the movement is to demonstrate that there is an absence of facts in the record, viewing the record in the light most favorable to the non-movement, an absence of facts in the record that would be sufficient to show constructive notice. And we've done that. We've done that because once we make our motion and Dr. Kreiser is at issue,
I think basically your argument is that there's no constructive notice because back in 1979, a reasonable parent wouldn't have thought this was a problem.
Yes, and Judge Kreiser agrees because Judge Chimes had we were allowed a voir dire. There was a full direct and cross-examination of Dr. Kreiser in the course of this motion. That testimony is available to us and it is part of the record for our initial burden as the movement. Our prima facie case as the movement includes that testimony, and Dr. Kreiser agreed that her opinion rested on the 1972 law, and then it brings us back to that analysis. Dr. Kreiser reviewed all the rest of the facts in the record, and plaintiff committed to her opinion as defining the duty and the breach for purposes of not just this motion, but for the trial. This was on the eve of trial. Without Dr. Kreiser's opinion to say that in 1978 or 1979, these facts would have given rise to a suspicion, should have raised red flags, we don't have any support from Dr. Kreiser of constructive notice. In fact, I think she becomes our witness. And Dr. Kreiser, the court found she was qualified by expertise, just didn't have a foundation. So as a qualified expert, the fact that Dr. Kreiser doesn't have an opinion that supports plaintiff's argument of constructive notice, that becomes affirmative proof in our favor. Now, I'm not saying you have to have an expert opinion. It certainly matters when you're talking about something that happened 30 or 40 or 50 years ago. And I would argue, but it's not necessary here, I would argue that that would be essential for jurors at a trial. But even leaving that aside for purposes of argument, then you can turn to the testimony from the fact witnesses, including those 5 teachers. Plaintiff was allowed to depose any teacher, administrator, anybody who's still alive and available. They were all deposed, and not one of them said that anything they observed raised a red flag, gave them concern about Mr. Penzel, or thought that there was something untoward in the way of sexual abuse going on.
What about the 2 teachers that appeared at the house of the young man who the defendant was babysitting? Does that not raise some red flags?
It didn't until the teachers were asked. That was Mr. Moy was one of those teachers, and he was asked whether he thought that meant that there was whether he was concerned that there was sexual abuse going on, and he didn't find any reason in that to report anything, to inquire further. This is at home. The child is under the supervision of the parents. The parents are the ones who are having this teacher, Mr. Penzel, babysit. If anything, that would give Mr. Moy reassurance.
I don't think the teacher or teachers went to the house while the parents were there to ask whether the young man was okay with the parents watching them, right?
Yeah.
I think the teachers went to the house when they learned that the defendant was there babysitting, which means that he's now taking the place of the parent in that home.
Yeah.
Because the parents aren't there.
So
Right.
I don't know that the testimony is that they went there out of concern because he was babysitting. There was some reason that they went to the house, but it wasn't. Counsel characterizes this as like some kind of a safety check.
Okay.
I don't think that that's what Mr. Moy testified.
What was the reason?
He simply said, I don't.
What does the record tell us?
I don't recall the reason that Mr. Moy gave. He did say, he said it's everything all right, and he was told everything's all right, and that was.
Sounds like expressions of concern.
You'd have to read the entirety of that testimony to get it judged. But whatever led up to it, whatever he saw, whatever he observed when he went to the house, he had no concerns. He didn't believe that this was any cause for. In 2025, we would all of these things would be clear red flags. We've all become educated. This court has dealt with so many of these CBA cases, and we all have. And we all see this thing through our 2025 eyes and experience and knowledge.
Should the jury be determining whether or not the appearance at the home there was these teachers waving a red flag?
Not when you have an expert and 5 teachers who were there at the time, who knew what they knew and understood at the time, who were aware of what the state of knowledge was and the standard of care was at the time. When all of those professionals agree that none of this was cause for concern at the time, that is the definition of the absence of tribal issue of fact. That's what the evidentiary proof adds up to in this case. And that means we met our burden, both on the initial burden as the movement, and then ultimately
they're being deposed how long after the fact about what their concern was back then? Was it decades?
It was decades. It was in the last 4 years since this case has been pending. But the plaintiff pushed really hard. One of the teachers, I can't recall which one, kept saying, in effect, and this is actually quoted, this part of this teacher testimony is quoted in the plaintiff's brief, Judge, so you won't have a hard time finding it. The teacher is being asked whether or not this topic, the subject of sexual abuse of students in school by teachers was even being talked about. Was it something that was discussed or known at the time? And the teacher keeps saying, at the time, nobody was talking about it. And the questioner, plaintiff's counsel, keeps saying, well, do you mean that nobody wanted to talk about it? And this is repeated 2, 3, 4 times. And repeatedly, the teacher says, no, I want to be clear.
Here's the problem.
Nobody thought about it.
Here's the problem I'm having, counsel. Do they have to get to the point where they're saying the concern was of a sexual nature? Or the concern was that this was very unusual conduct. We have a red flag we're flying, we're going to the house, and we think further inquiry ought to be had and we think that this is enough of a red flag that we ought to be sitting down and talking with these students and talking with the other teachers and talking with the administration, whether it's sexual or not. You may be absolutely right that back then, that was not the thing that was flashing red lights, right? But it doesn't have to be, does it? All that's we're asking here in terms of what a jury might consider is, was there more that needed to be done based upon the facts that were known? Am I not right about that?
That's a fair question, Judge, and that would be a harder case. I'll agree with that if the teachers felt that way and reached those conclusions based on what they had seen, that would be a much tougher case. It's not this case. None of the teachers, based on what they actually saw, what they actually observed, what they actually knew, had even that level of concern, had even that level of, shouldn't this be looked into further? Should this be known more? And given that, that is the definition of the absence of constructive knowledge, and that's why the district is entitled to summary judgment.
We'll take a look at it, counsel. Anything further?
Nothing, Judge. Thank you.
Thank you, counsel. Case 908, Washer versus the Memorial Hospital of William F. Jones.
Morning, Your Honors. Mary Lou Rocha, Tarantino Law Firm, on behalf of Dr. Taylor and Associated Radiology of the Finger Lakes.
Thank you, counsel. We're going to wait for your opponent to come onto the screen. I think he's scheduled to be, yes, very good.
My apology.
No. No
Still get
apologies
used to
needed,
the
counsel. Thank you for
technology.
identifying yourself. Appreciate it. Mr. Fitzgerald, can you hear us?
Yes, I can, Your Honor. Thank you.
Very good. We can hear you well. Counsel, please proceed.
Thank you, Your Honor. To start, there are two arguments that plaintiff now makes on appeal that he did not make below. The first one is that defendants did not meet their burden. That was not argued in the court below, and it's respectfully suggested it shouldn't be considered here. The second one is that someone should have called Mr. Washer because the PA in the ER and the radiologist read the chest x-ray differently. That wasn't argued below, and again, respectfully, it should not be considered. And then below, one of the main issues is below, for the first time in opposition to summary judgment, plaintiff brought up this new theory that although Dr. Taylor recommended a CT scan following his read, which was he saw something on the scan, and he said it could be a pulmonary nodule or it could be an old fracture. Dr. Taylor did recommend a CT if further follow-up was necessary.
Well,
And
he had no duty to order.
he had no duty to order, and in fact, he doesn't even have a duty to urge, according to some of the cases. And that's, so plaintiff's argument that it should have been unequivocal, that he shouldn't have put the if further workup is needed, was a new theory, and it goes beyond a radiologist's duty.
So, counsel, let me just clarify, see if I have it right. And we're talking about one of the allegations of the bill in particular, and that was a failure to recommend a CT scan exam, right?
Correct.
And is it your position that your client had no obligation to make a recommendation of a CT scan?
He had no duty to recommend it, but he
No
did.
duty, thank you.
But he did recommend it.
And he clearly recommended it.
He said if further follow-up is
What was the
necessary.
language that was used? If?
He did use the word if.
Yeah.
And there's a reason for that, Your Honor. And that's because as a radiologist, and in fact, as the PA in the ER, neither of them know if this is an old lesion or a new lesion. They don't know if it's being monitored or followed, or if it's been worked up already. They don't have any of this information. And that's why the word if further evaluation is desired, I think was the word he used. So, and the case law does indicate that it's for the treating physician to determine what is next in terms of treatment, not the radiologist. So, well, he doesn't have a duty to recommend, he did anyway.
Time out, counsel. Let me just ask you. it is the standard of care for a radiologist to make recommendations, correct?
It's within the standard of care for a radiologist.
You probably know I'm quoting directly from your expert's affidavit.
Yes, and the reason, while the radiologist doesn't need to do it, if he does do it, it's within the standard of care to do it. The standard of care does not absolutely require that they make recommendations. There's a difference there.
But here your position is, it is the standard of care for a radiologist to make recommendations. That's what your expert says. And here your radiologist client did make such a recommendation. So it's not like you're saying the duty does not exist. You're saying that you fulfill the duty.
I think I'm not doing semantics. I don't think I'm doing semantics here. I think the radiologist does not have a duty to do it. But if he decides that he is going to make a recommendation, it's within the standard of care to do so.
And plaintiff's experts attested that under these circumstances, given the findings that the plaintiff's experts saw in the radiologist or in the x-ray, that a different read was appropriate, and that different read should have prompted an unequivocal recommendation for a CT. That's essentially what the expert says for the plaintiff, correct?
That's what the expert says. It should be unequivocal. But then by saying that, it takes away the treating physician's right to determine the next course for her patient, which she had treated for 10 years or so. And she's the only one that knows, the primary care physician is the only one again.
But even if the radiologist, under the plaintiff's expert theory, had made an unequivocal recommendation for a CT, the primary didn't need to follow that recommendation because the primary knows the patient better.
Absolutely.
Okay. So that my point is that the plaintiff's theory about if is in the case by virtue of the plaintiff's expert affidavit testimony that says if defendant radiologist had properly read it and seen these signs and indications of potential cancer, if the radiologist has done so, he would have then appropriately, unequivocally recommended a CT. That's the theory the plaintiff has, correct?
Well, and that's a new theory because
But how could it be a new theory if it's in the plaintiff's expert's affidavit?
Because it was not in the bill of particulars and it was not in.
Recommendations were not in the bill?
The unequivocal recommendation was not in the bill. The that he should have recommended a CT scan was in the bill of particulars. But the new theory is that he should have unequivocally recommended it. And that's why I think
the bill has to specify the exact fine tuning of the expert's opinion.
I think it's a whole new opinion. When you say that he didn't recommend a CT scan, we know he recommended a CT scan. To say now that it should have been unequivocal, that's a whole new theory.
But the law is that the plaintiff doesn't have to hire an expert to respond to bill of particulars. So in terms of getting that fine tuning in the bill of particulars, you had the general gist in the bill based on the absence of a recommendation, correct?
Didn't, Your Honor. I didn't know that it was going to be an unequivocal. Otherwise, I would have had my expert initially comment on that in the first instance. So that was a surprise that it was supposed, especially given the case law where they don't even have a duty to recommend anything. So it was new to me and it was a surprise to me.
The fundamental distinction is that your expert says that Dr. Taylor appropriately read the x-ray and the plaintiff's expert says he did not.
He did not because Dr. Taylor said that what was seen could be a subtle old fracture. But it doesn't, even if we accept that, okay, there's a battle of the experts in terms of whether or not he properly read it, there was no proximate cause stemming from that because Dr. Osborne, who's the primary care physician, said that had she received the x-ray report, which she said she never got, has nothing to do with Dr. Taylor, why she never got it. Had she received that, she would have done a CT. So the fact that there were two possibilities of what this nodule could represent made no difference to her. She would have done the workup, but unfortunately she didn't get the report. And P.A. Mathiasen said, it didn't matter to me what was seen on that CT, on that chest x-ray, but for the fact that Mr. Washer, didn't have a pneumothorax. That was what I was there to do. That was what I was there to determine. He had an appointment with his doctor 2 days later. She was the one to best know his history, best know what to do. She was the one to diagnose and treat. My only concern was whether or not he had an emergent situation, which would have been the pneumothorax. Now, the court, in trying to, and I quite honestly had never seen this before, in trying to bring up an issue on proximate cause, says that Matthias had Dr. Taylor not put in that the possibility of a subtle fracture versus a pulmonary nodule, then Matthiasen would have put it in his report. And then Dr. Osborne would have known about it because it would have been in his report. That is absolutely contrary to everything Matthiasen said. He clearly, and I don't mean to be reiterating, but he said, I would never have done any of that because I was only looking for pneumothorax. The only thing that would have changed what he would have done is if he knew that Dr. Osborne was not getting the reports, he would have either called her or made sure that she somehow got the report. He wouldn't necessarily have put it in his history and physical, which was a summary of what happened. So I don't know where the court came up with that idea. It's purely speculative, it's conclusory, and it goes directly against the evidence in the case. As far as if the court has any more questions, I'm happy to answer them. Otherwise, we can rest on our brief.
Very good. Thank you, counsel.
Thank you.
Mr. Fitzgerald.
Thank you, Your Honor. May it please the court, I'm Brian Fitzgerald. I represent the respondent, Sharon Washer, individually and on behalf of the estate of Luther Washer. In opposing the defendant Taylor's summary judgment motion, plaintiff submitted the affidavit of an expert in radiology who clearly states he doesn't create a duty where none otherwise exists. He simply articulates on the standard of care as to what the defendant radiologist Taylor has to abide by. Taylor should have found that what was seen was a lobulated density measuring 2.8 cm by 2.7 cm overlying the 5th and 6th ribs. He should not have said it could be callus. Callus is the growth of bone on a fracture. It was not callus. Taylor was incorrect to say it was callus. If it's not callus, then it's a mass in the lung, which might be benign, might be malignant. That creates the standard of care on the part of the radiologist to make a recommendation. We have to find out if that mass is malignant or not. Get a CT scan. When Dr. Taylor uses the word if, that makes that an equivocal recommendation. It's not a clear recommendation. The bill of particulars states, failed to recommend CT scan exam. Failed to ensure that he'd be followed up by CT scan. The claim by the defendant Taylor that somehow this theory of an unequivocal recommendation was never articulated is nonsense. It's in the bill of particulars. Now, on the question of causation, Matheson testifies that he's an emergency room physician assistant. He's looking for and trying to diagnose what's the emergency. There's a history of Mr. Washer falling. So does he have a fractured rib? Does that cause a puncture of a lung, a pneumothorax? So he reads the film. Matheson reads the film. He actually has credentials to read the films. And he writes in his medical decision-making section in the ER record, which Dr. Osborne later reads, 2 days later when she sees Luther, he writes no pneumothorax. But he doesn't write what the radiologist, Dr. Taylor, has said about it, that it could be this mass or a density. Why doesn't he? This is his testimony. So, did the thought occur to you that with respect to the reference to pulmonary nodule, that it might be malignant? No. Question, tumor. Why didn't that occur to you? Answer, again, the radiology report was equivocal, and that was never in my differential diagnosis. So Matheson clearly, that testimony clearly establishes that when he sees this equivocal if radiology recommendation, he's misled. And since he seems to be just concerned on whether it's pneumothorax or not, that's all he writes. But what he should be writing is, there's a density seen. And had he done that, Osborne would have seen it 2 days later, and she would have done something about that density. And there's
Mr. Fitzgerald.
And
Mr. Fitzgerald, let me just interrupt you. Don't lose your train of thought, but I want to make sure I get these two questions out before you get totally into and finish with proximate cause. Vis-a-vis the defendant's argument on summary judgment that Dr. Taylor had no obligation to specifically order the CT, you don't oppose that, correct?
we've never made that argument.
Fine. On my second question along the same lines, when the defendant argues in summary judgment that Dr. Taylor had no duty to directly communicate with the decedent, you didn't oppose that either, correct?
Well, that's an interesting issue. Because there is in the record the hospital's policy that if you are a patient in the ER and the ER reading is the ERPA's reading is somehow different from the radiologist's reading, we will call you. There's no explanation in this record why Mr. Washer, when the radiologist's reading is talking about a nodule and the PA's reading is talking about no pneumothorax, those are different readings. Why aren't they calling you?
Forgive me if I'm not following you correctly, Mr. Fitzgerald, but that would be the hospital's policy and the hospital's duty, correct?
Well, that's a question of fact. If that's part of the policy and procedure on how x-rays are read and handled and reported on at the hospital, what's Taylor's duty? How does Taylor know that his reading is different from the PA's? What's going on? Who makes that determination that there's a different reading and then calls Mr. Washer? It's a question of fact all over the place. So, Matheson's testimony clearly establishes that the reason he doesn't do anything about the density is because he's misled by the equivocal reading. That gives you proximate cause. I also like to point out that it's the defendant's burden on the proximate cause issue. They have a burden. Defendant Femia's expert opinion doesn't comment on causation. Take a look at it. There's no opinion as to a lack of causation. It's also as to the standard of care conclusory. All it says is Dr. Taylor met the standard of care. That's conclusory. Dr. Femia, the defendant's expert, never says in his opinion that plaintiff's expert's report opinion, that it was a lobulated density separate and apart from lung tissue, and it was not callus on a rib. Dr. Taylor's expert opinion by Dr. Femia never says that's wrong. Never says that's wrong. As a result, we clearly have established a deviation from the standard of care. We've clearly established causation, and we believe that summary judgment should have been denied. Plaintiffs concede that there's a battle of the expert as to the expert opinions. Quite frankly, with their conclusory opinion by Dr. Femia, I don't think they'd even get to a battle of the expert. But that's our argument, and we appreciate the court's attention and concern. Thank you.
Thank you, counsel. Case 909 Madeira versus Kaufman, MD.
Good afternoon, Your Honor.
We're going to hold on 1 second there, counsel, please. We got to make sure that we have everybody present. Counsel, very good. Can you hear us? Continue to hear us?
I can. Thank you.
All right, very good. Counsel, proceed.
Thank you, Judge. Good afternoon, Your Honors. Kevin Hunt on behalf of the appellant. I'm from Syracuse. I represent the 3 young physicians in the hospital where they were training. in 2020, when the delivery of this baby took place, May of 2020. Those physicians are Doctors Tran, Chi, and Ono. If I may, I want to start by saying your honors are as well familiar with the law as I, and more so probably, that residents in the state enjoy a shield, a conditional form of immunity, one might call it, because of their very status. They are young doctors who are learning to become full-time attending physicians. And so, judges, we made a motion for summary judgment. There were several issues, if you may recall, and several other defendants in the case at the time, but all that remains now is the case against my 3 residents. And so my appeal here today has to do with that residence shield, residents plural. And just a minute more so I can organize my thoughts, and it might help the court. In the case, there are 2 parts. There are the residents, Doctors Tran and Chi, who were administering the laboring section of this pregnancy. The day is May 19th. And then the 3rd resident, Dr. Ono, was there for the delivery. So the 2 cases, the case may be split in those 2 sections, those 2 buckets, so to speak. So then addressing the first part of it, Dr. Tran was a first-year resident who was being supervised by Dr. Chi, who was a 4th-year resident, and together the 2 of them were being supervised on this day in question by Dr. Burke, the former defendant, and well-seasoned attending physician. Now, the process took place whereby Dr. Tran would see the patient in her room. Oftentimes, a nurse would be present, conduct an exam, take a history, have a discussion with the patient, and then report those findings to either her senior resident or Dr. Burke, or together the 2 of them at the same time. And then based on that, a plan would be made, whether it was status quo, don't do very much of anything, or
Counsel,
yes, Judge.
we get that part of it, but I think the issue here is the reporting back. Like Dr. Tran is responsible for reporting information regarding the infant's heart rate.
Among a whole number of things. Yes, Your
One
Honor.
of the principal issues here, the heart rate. And the question is, did Dr. Tran report the measurements, or did Dr. Tran make an evaluation as to whether those measurements should be categorized as category 1, 2, or 3? Correct?
Dr. Tran reported far more than that based on this record,
Right.
Your Honor.
And
But certainly the fetal heart rate is an important part.
That's the plaintiff's position here, is that Dr. Tran's reports were inaccurate, that Dr. Tran was reporting category 1 when looking at the raw data, this should have been reported as a category 2. And that whether or not the issue I think we have was Dr. Tran's interpretation of the data as a category 1, category 2, an independent medical act.
Not if the attending then takes that information, has a discussion with the residents, and decides on a plan. It's definitely their position that Dr. Tran misread a few of these strips, not the entire afternoon, as AB suggested, but at one particular time in the afternoon, the plaintiff has made that argument, which I would submit they have to, because that's the second part. That's the second issue that has to be decided in these cases after the shield issue takes place. Remember, this is a young physician who's entitled to make mistakes, who's not expected to know.
You said you've indicated, I think you admitted that she misread some of these strips.
It's arguable.
You just indicated, well, I thought
It's
you did.
arguable she
I thought you just
misread.
indicated that you did. But all right, maybe it's arguable. But I guess the question is too, to follow up Justice Alcani's theory or line of questioning, excuse me, was that whether or not Dr. Tran was certified to read these? Because apparently there's an understanding that after your first year you can become certified. But
Yes,
it's
sir.
a question of whether or not Dr. Tran even had the certification to do this.
No question. There's no question Judge, about that. She was not certified. She was in her 9th month of the first year of her residency. That exam is taken at the conclusion of the first year. So she definitely was not certified to read strips. But again, I submit to you that that's not
Was she
decided.
in charge of that though?
Pardon me?
She initially read the strips.
She did. Yes, Judge. She did read them, reviewed them with the 4th year.
Then reported.
And then reported to the attending. The attending has access to those strips. The attending can countermand the interpretation. The attending can agree, the attending can do whatever. I mean, the attending is in charge.
Isn't there a testimony from Dr. Kaufman that they misread them? They were actually 2 when they.
There is, Judge. Yes, Dr. Kaufman agrees in part with the plaintiff's expert interpretation of those strips. But again, I submit to you, Judge, that's the cart before the horse. That does not matter as far as the resident's shield is concerned. The resident can be incorrect about those things. But as long as she is reporting those findings to the attending physician, which this record amply demonstrates.
Is it as simple as the resident cannot make the interpretations with respect to the strips and then take action on their own in response to that interpretation? And as I think I hear your argument is that didn't occur here. Rather, the residents interpreted the strips, but then always went to the primary. The attending physician, and provided that information and got guidance and supervision as to what next steps were.
Direction. She got direction about what next steps. Judge, you're talking about Heinrich. I think you were on that one. I apologize. I know Judge Kern, the two of you have been on those cases, Blendowski, Hatch, and Heinrich. My office is in all 3 of those. In Heinrich, I actually tried that case, Judge, 2 years ago. We came back in front of you all 3 or 4 months ago to talk about the missing witness issue. But earlier, like 2 or 3 years before, this court decided Heinrich. The resident in that case, who wasn't my client, the Attorney General represented the resident, Dr. Patel. They made a motion for summary judgment that she should enjoy a shield because my client, Dr. Cleary, was the attending who was supervising Dr. Patel. But on summary judgment, there was an issue of fact on whether Dr. Patel had ordered some tests and some medications, but didn't review it with Dr. Cleary. And so the trial court said issue of fact, and you all said affirm issue of fact. And we went back and had a trial 2 years ago, which, as I said, is now being set aside because of a completely unrelated issue. But Judge, you hit the nail on the head. As long as the resident did not sort of act roguely and make these decisions or choices on her own, she cannot be liable in the state of New York. So that's the first part. The second part is Dr. Ono. If I may have just a minute more just to discuss on her behalf. The case against her is involving the delivery itself. She's standing under center with a senior resident and the attending Dr. Kaufman, whose name you mentioned earlier. Dr. Kaufman now is involved at the time of the delivery. And Dr. Ono is a first year, and she's given an opportunity to try to deliver the baby when the shoulder gets caught and there's an arrest of the delivery. And after less than a minute, Dr. Kaufman steps in and takes over and delivers the baby. And unfortunately, she had to break the child's arm in the process. And there's a claim for that, for sure. Judge, given the direct supervision that was taking place by Dr. Kaufman, she's literally standing next to the resident who's at the perineum. The resident should enjoy the shield. And I would submit that situation is like Blendowski, which was the knee surgery where the resident's drilling into the knee replacement and Dr. Weiss, the attending, is standing right next to him. It's like the Hatch case where the resident is retracting, I think it's the aorta. I mean, there was a serious vascular surgery in that case, and the resident is holding the aorta so that the vascular surgeon can fix or repair.
Counsel, let me go back to the facts of this particular case though, right?
Yeah.
Because in the delivery room, this first year resident is instructed, at least as we understand it, to do a very technical maneuver.
Yes.
And the record though indicates that the patient and the father of the baby are worried, saying, you're pulling on the head, you're tugging on this head.
Yes.
Their observations are, you're not exercising a maneuver here. This is not, and in fact, the attending doctor then jumps in and says stop or has some kind of a
yes
indication. So there is no limitations. I mean, understanding that the resident was indeed, on the set of facts, asked to perform this maneuver. That means the resident can do anything as long as they're instructed?
Almost
anything. That's your position?
Yes, sir. The attending is standing right next to her.
So if the attendant had
Watching.
struck the baby or something of that nature, that would have been fine too? I mean, once it's turned over to the resident and the attending is standing there, the resident is free to go. It's got full shield.
Just about, Judge. I think I would say so. I think what the case law says. Hatch is comparable, where the resident has retraction on the aorta and arguably pulled too hard. The aorta gave way, which resulted in a much more complicated surgery. They had to patch, they had to do all kinds of things. This court granted that resident, affirmed, I should say, you all affirmed the summary judgment that was decided below. I just want to say one more thing, judges.
Counsel, can I say one thing?
Oh, please, yes.
And please, forgive me, but I'd like you to stay a little more tethered.
Sorry.
It's not in a courtroom and we have people watching. And so if you proceed with your argument that way, I'd appreciate it.
I acknowledge that, and I beg your pardon, Judge. I feel strongly about this case in large part, Judge. This case is going to trial in a week, and I was going to end on this note to let you all know that. I know it would be most unusual for the court to rule from the bench, but I know you're extremely busy. I sat through a number of complicated and intense arguments, and I know you're busy all the time anyways, but I would urge you, Your Honors, to consider what it is that we've laid bare here. And if it is at all possible, if you're feeling the way that we do about this, that you issue your ruling to save my 3 physicians from coming to Syracuse. They're coming to Syracuse on Saturday and Sunday to try this case beginning on Monday. They live in California, south side of Chicago, and Queens. I truly believe the court below was incorrect in reaching its decision. And I'm bothered by the fact that the court refuses to adjourn the trial to allow your court to make this decision. I've made that motion twice, and that motion has been denied. My sense is it's for vain reasons, but I'd like to leave it at that and would appreciate your consideration.
Thank you, Counsel. Counsel, proceed.
Good afternoon and thank you. I appear on behalf of the plaintiffs. I might jump around a little bit, but I would like to address a couple of points before I dig into the arguments. This court denied defendant's stay application. So the contention that the trial hasn't been stayed because of a matter of vanity by the trial court is inaccurate. This court reviewed the applications of the parties and denied the stay application. Secondly, Judge Del Conte, I would like to point out with respect to Dr. Ono, there's no testimony that Dr. Ono was directed to perform any maneuver. Reading from defendant's brief at page 6, Dr. Ono did not recall performing the Woods maneuver. And he says, but if the doctor had directed her to do so, she would have. So there's no evidence that that attempt was made. Continuing with the liability of Dr. Ono, what the defendants have failed to acknowledge here, and their expert did as well, is that the plaintiff and the father of the child, in their testimony at pages 5082, 5213, and 5215, said that they were upset and disturbed when they observed a resident pulling on their child's head. With this resident, it was the first time she had encountered shoulder dystocia in the face in the setting of delivery. That's at page 345 of the record. The plaintiff then also testified that a doctor, a 6-foot-tall woman, intervened and said, no, don't do that, get out of the way. That's at page 5083 of the record. So there's a question of fact for a jury to decide whether or not Dr. Ono's act of pulling on the child's head was an independent medical decision, particularly given the fact that the attending said, no, don't do that. If the attending said, no, don't do that, that implies to a jury or a fact finder that in fact, Dr. Ono was never directed to pull on the child's head in order to deliver the child. With respect to Dr. Tran, perhaps a brief recap on the medicine, right? Fetal heart tracings are reviewed by the resident. Here it was Dr. Tran, and a determination is made whether category 1 or category 2. The difference gives rise to difference in treatment. If it's category 1, you continue to administer Pitocin. Pitocin increases contractions. Contractions decrease the flow of oxygen to the baby. So it can be dangerous if the baby's in fetal distress. When it's category 2, according to Dr. Kaufman, the baby should be delivered within 1 to 2 hours. And that's at pages 202 to 205 of the record. So whether or not when a resident reviews these tracings and makes a decision of Cat 1 or Cat 2, it's a meaningful determination. It turns on whether or not we're going to continue to treat the mother in a manner that may further deprive the child of oxygen.
But counsel, let me interrupt you there on that particular point. That point it holds, it seems, if in fact Doctors Tran and Dr. Ono, once they do the readings, make a determination based upon that reading without consultation with their senior doctor. Your opponent is saying that never happened.
Well, according to Dr. Tran, her words at her deposition at page 665 were that every time I make an assessment, I would tell the attending. In other words, I tell them it's category 1. So there's no testimony that anyone verified that Dr. Tran's reading of the strips was accurate. And in fact,
Well, does that matter? Does that matter? It would be my question, because let's say that Dr. Tran improperly read the strips and reported the bad rule or the bad interpretation onto the attending. Let's just say that's what happened. Isn't it still the attending that has to make sure that relying upon that was a proper thing to do? In other words, if the attending relies upon Dr. Tran making that interpretation, and Dr. Tran made it inappropriately, made a mistake, isn't that the whole idea of Dr. Tran going to the attending and saying, here's what I found, but you're the attending, you make the call?
I don't know that necessarily makes a difference for our purposes. The bottom line would be that Dr. Tran exercised independent medical judgment. The fact that the attending allowed the resident to do that and that this had consequences to the child goes to the physician, the attending's liability. It doesn't alter the fact that Dr. Tran made an independent medical decision. I mean, arguably,
wouldn't the independent medical judgment be the exercising of an act after the wrongful interpretation of the strips? In other words, a reliance on the wrongful interpretation of the strips resulted in an act being taken as part of the care. But that act doesn't happen without the attending making that determination.
But it is the fact that the resident made the independent medical decision. The attending accepted it. That goes to the attending's liability.
I understand your argument, and I'll have to take a look at that. Go ahead. Continue.
Yes, because again, everyone relied on Cat 1 findings. Dr. Kaufman at page 210 to 214 reviewed the certain strips and said that they were in fact Cat 2 when they were identified by Dr. Tran as Cat 1. And Judge Montour, as you pointed out, this resident had yet to be certified in the reading of strips. If anyone required verification, it would have been this first-year resident.
Tran and Ono Ono were not certified in this, right? In the reading of these strips.
Well,
and the attending knew that, right?
Well, Ono was not involved in the issue with respect to the reading of the strips. Thank
you. But let's stay with Tran then. But the attending knew that Tran wasn't certified for purposes of reading the strips. Doesn't that even more lead it up to the attending to take action if the attending decides to take action based upon what Tran interpreted?
There's no indication in the record whether the attending was aware of Tran's lack of experience or even certification here, Your Honor.
Isn't that the attending's responsibility to make sure that they know what the residents can and cannot do and what they're capable of doing?
It should be, but again, that would go to the liability of the doctor. It does not place a shield over the resident, because then arguably you would, in any case where there's an exercise of independent medical judgment by a resident, we could all turn around back and blame the attending, and then you've just nullified the independent medical judgment exception. Here, they clearly, there was only one person on this record who made an evaluation of the strips and evaluated them as category 1. There is no testimony that anyone went back and looked at the strips. So that was an independent medical judgment. We cannot.
Counselor,
Yes.
if the reading of the strips, as I understand it from your expert's affidavit, it requires sort of a comprehensive evaluation. It isn't just taking the strip off the machine and reporting. The resident could have done that, reported what I understand to be the raw data. But your expert's position is, I think, that you can switch in between category 1, category 2. You got to understand where you were previously, and you've got to sort of monitor the patient all through this process. And the fact that when you evaluate a patient and you say it's category 2, you're really ordering no follow-up. When you say, or you say category 1, I'm sorry. If you say category 1, no follow-up. If you say it's category 2, the patient gets additional treatment. And that's the exercise, right?
Right. Category 2, you should be delivering the child within 1 to 2 hours, according to Dr. Kaufman. And our expert explained that there was the readings were category 2 of such a degree that they should have reduced Pitocin and stopped administering Pitocin. And even Kaufman and Burke admitted that that is the proper process here. So that's the issue. Because Tran only reported category 1, and then there's no explanation by Tran whether or not she did a holistic review of the strips. Our expert performed the holistic review, and referring the court to pages 1202 to 1204 of the record, paragraphs 40 to 46 of his affirmation, he says that in the setting of these readings, these were category 2 of such a degree that the administration of Pitocin was improper and contrary to the standard of care. I'd point out that the defense expert, and perhaps I can finish on this, the defense expert never articulated what the standard of care was. He uses the word standard of care in his affirmation, but he never articulates what the standard of care is. And the defense counsel in their reply brief took issue with our pointing out, the plaintiff pointing out, that Dr. Dropkin submitted 2 different affirmations in the context of 2 summary judgment motions. In our affirmation in opposition and our expert affirmation, we pointed out that his affirmations were in conflict. For example, in one affirmation, he stated that Dr. Ono stopped immediately when he encountered shoulder dystocia. And that's at page 1140 of the record, because he was on this record representing Dr. Ono. But in the context of the other summary judgment motion with respect to Dr. Kaufman, Dr. Dropkin said that Kaufman allowed both Ono and Gregory to attempt delivery. And what we had pointed out in our answering brief was that this court should take judicial notice that Dr. Dropkin's affidavits and certain of his opinions either conflicted with the record or conflicted with his earlier affidavit. Defendants have argued that we were not permitted to cite to this other affirmation and that we had to cross appeal on this. The arguments were raised in the affirmation in opposition. They were raised in the expert affirmation. It was fair to ask the court to take judicial notice of it. And clearly it goes to the credibility of a doctor's opinions when he testifies in one direction with respect to when he's representing one set of defendants versus another. He also opined at page 1210 actually 1170, that there was a successful delivery of the baby, when the records show that this was an Erb's paralysis due to a birth injury. So his affirmation really did not support a prima facie case. He also opined in his affirmation at page 1139 that there's no difference in treatment whether the strips are category 1 or category 2, when in fact Dr. Kaufman admitted that there's a difference in treatment and that you deliver when a patient is a category 2 within 1 to 2 hours. And that's at page 2023 to 2025. So our point here in the argument that we raised was that the defendants never met their burden of proof in the first instance. Their expert affirmation defeated their prima facie proof, especially when you consider the other expert affirmation. And we were not obligated to cross appeal on this because we were not aggrieved. Under 5511, we were not aggrieved by the court's denial of summary judgment.
Thank you, counsel.
Thank you.